May I mention, Lord, item 335 of today's list. It is a contempt application seen from not expect. The Lordship kindly update. I going to serve Mr. Banerjee. He refused to.
Which Mr. Banerjee?
Mr. Howard, Mr.
Shondipan Banerjee. He will be there at 2 o'clock.
But I am
Let us see, but then I cannot say whether I'll be able to upgrade today because there is a lot of pressure today. It is pending. I take up upgradations every Thursday, but then today possibly it will not be possible. It will not be possible.
Lord, may I, my lords, kindly, my lord, to mention, Lord, an application for extension of interim order, Lord, last extended by your lordship in March, my lord, which is still expiring, Lord, next week. I'm grateful to lordship.
Lordship, this is another application for extension of interim order.
My lord, under some compelling circumstances, my lord, a senior citizen, my lord, has been kept in lurch. My lord, I'm a senior lurch. My lord, my insurance policy, my lord, has been repudiated. My lord, without giving me an opportunity of hearing. My lord, without disclosing me the reason.
Where is the matter?
My lord, I seek to, my lord, leave.
File it in the department.
My lord, there is some urgency. On 27th, my lord, my policy is to expire, my lord. If they don't renew, my lord, I'll be left without any remedy, my lord. My lord, there is some.
I think the writ court will direct them to renew our insurance
My lord,
policy.
at least,
What else
my
is
lord,
the writ court do?
I have made a representation, my lord. I have a right to know, my lord, the reason for repudiation, my lord. My lord, they have not even informed me.
Please file it in the department. The court is not granting you leave.
My lord, I am saying to leave, my lord, to move this merit petition on urgent basis, my lord. My urgency is that, my lord, the private respondent bid, my lord, was accepted without, my lord, the fulfilling the eligibility criteria, my lord. But the tendering authority are going to issue the work order, my lord.
Then bid has been accepted. What is the stage? The technical evaluation has been done.
There is objection, my lord, but they did not take any steps, my lord.
And when is financial bid also opened? Then why do you come at this stage?
I made the several representation, my lord, but they did not consider my representation, my lord.
Very well. Monday it will appear. Give.
Lordship, restoration application for upgradation, Lordship.
No.
I'm praying for leave to pray for a very no-cost prayer, my lord, passed by your lordship in 2023 for Puja permission, conducting Durga Puja. Well, similar orders were passed in also 2024. My lord, I have come up with a fresh petition.
Every year, why you have to approach court?
Knows, my lord, your lordship was pleased to pass an order in my favor in 2023. This is with regard to Maheshwala Municipality. There are several litigations, round of litigations, my lord. Every year I have to knock the doors of justice, my lord. If it may kindly appear, my lord, I'm praying for leave to file and appear on 27th. A very innocuous prayer, my lord.
Very well, file.
I'm so grateful.
Serve.
I will serve.
May I permit to mention, my lord, one matter, item number 540 of days list, contempt matter. In this matter, my lord, your lordship was pleased to pass an order at 24th July. Kindly see, my lord.
No, tell me what has happened.
It requires some modification, my lord.
Modification?
Yes, my lord.
Then you have to come up with an application.
My lord, I am mentioning item number 280 of your lordship's list, my lord. This is a contempt matter. My lord, your lordship directed them to pay the gratuity and the other part, but they are not paying, and they had filed one appeal. Appeal was dismissed. Thereafter, they are filed leaving, but there is no stay order in the review. So, my lord, in this regard, my lord, I have given notice to the state authorities because DI is the authority to transfer the state. Well, let it be taken up, my lord, any day, my lord. If your lordship, I am giving notice.
Today, it will not be.
Today is the contempt day.
Yes, but
If
today.
you fix the matter at any time, then I shall give the notice to my other side, the state authority. Jayanto Samanthi is appearing.
280. All right, give notice.
Lordship.
280.
Lordship.
At 2 p.m. I shall.
After the regular contempt is taken up.
I am mentioning under urgency, my lord.
Where is the matter?
There are two matters which are appearing as item number 208 and 209 in the daily list of 14th August. My lord.
14th August.
My lord.
Yes.
There is urgency, my lord. My MBBS seat has been cancelled because my scheduled tribe certificate has been cancelled wrongfully and without following any procedure, my lord. I am not unable to continue my studies. Let the matter be fixed on Monday, my lord. I am mentioning on notice.
Who is your other side?
Mr. Shangsu Bhattacharjee, advocate. Mr. Loknath Chatterjee, Mrs. Sumita Shaw, advocate.
The names you have mentioned, they are appearing for the Union of India. Who is for the state?
Loknath, Mrs. Sumita Shaw.
Monday, all right, give.
Deeply obliged. Your
May my lords kindly leave my lord to mention, my lord, I am mentioning.
What was the order passed?
Order was passed lordship on 4th of April, thereafter it was returnable. So it is proceeded for the party had municipality.
Yes.
At the time lordship
So what was the order passed?
for demolition of the lordship building.
So what has the age got to do with it? If today it is not demolished, tomorrow it will be demolished. What is the 81 years old?
The petitioner is not in a position to came out of the building.
Why?
Because in front of the building's main gate, lordship, the construction has been raised. Now, the cooler lordship leaving the said house lordship due to the problem of the
Ingress and egress problem, the civil courts are there. Please do not mention. Very well, rule was issued, the matter will be taken up. No, it cannot be done.
My lord,
May I
may I
mention?
seeking
Sorry.
urgency is that, my lord, upon compliance of the obligation, petitioner presented the registration of his deed, but behind my back they have increased the circle rate. Earlier, I have
Circle rate will be increased behind your back.
my lord, just
Hmm?
my lord,
Is it increased only for you? Circle rate means
No,
for
no.
the entire circle.
actually I have got the assessment slip from the portal and I
Yes.
paid according to that registration
Right.
fees and everything. When I presented my deed, they said that the circle rate had enhanced.
Increase, nothing.
Just one day before, my lord, similar flat was registered in the same premises. There was circle rate was 7,000. When I'm going to register my deed, just one day after, they said that now a circle rate is
File it in the
8,000.
department.
8,000.
Yes, what were you
My
mentioning?
lord, kindly take it. Otherwise,
No,
until and unless I complete my registration, owners will not give me the possession of the flat.
obviously, file it in the department. Yes. You want inclusion on the day? No.
May I, my lords kindly, my lords, I'm mentioning pursuant to leave granted by my lord to mention this matter, my lord. I'm suffering an interim order of stay, my lord. Bank, the entire surfacey proceeding has been stayed.
Yes.
That it's item 518, my lord's list, my lord. Lord, kindly, any day, my lord.
So
Kindly,
why are you mentioning? You are
my lord has given me leave. To
leave
give the
to
parties the
mention
right
for
to exchange affidavits, and after affidavits, my lord, I was given leave to mention, my lord, because I was
mention
suffering.
before some other bench. This bench cannot hear.
My lord,
Sorry, sir.
I'm suffering.
No, no. Try out some other bench.
My lord,
Yes.
may I be permitted to mention item number 206 of today's list, my lord. This is a new motion, my lord. I have filed it on Monday. My lord, the urgency is that, my lord, that the West Bengal Rifle Association, my lord, they are organizing one event on 25th. My lord, I am one affiliated institute. I am a company. One of the directors of the company, he tweeted something against the portfolio holders of the association. Now, they have banned the director as well as they have suspended, my lord, the institute also, and they are only allowing the wards of the institute to participate under the banner of the West Bengal Rifle Association. And from this event, my lord, my lord, wards and the students, my lord, they are going to be selected for the state, my lord, meet as well as
Then
for
where
the
is the
national.
difficulty?
My
The
lord,
wards will be there.
yes, my lord, but my lord, they trained under me, my lord. My credential would not be there, my lord. I would suffer my business because that is my business, my lord.
No,
My lord, that
no,
is the, my lord,
no,
my lord, kindly hear it any day, my lord.
no, yes.
My lord, my lord, kindly once, my lord, for the fault of the director, my lord, the company cannot be suffered, my lord.
No, yes.
May I mention item number 549 of today's list, lordship? Today the date has been fixed for the appearance of the alleged contempt, lords. The contempt is appearing, lords.
Hmm. You are for whom?
For the contempt, lord.
2 o'clock it will be taken up. Who is your other side?
Mr. Mihis Saha.
Call him. 2 o'clock, please mention. Let your client remain present.
My lord, may I be permitted to mention, my lord, on 19th of August, my lord, your lordship had passed an order, my lord. My lord, the orders have still not been uploaded, my lord. My lord, the client has preferred an appeal, my lord, against that order. My lord,
Please wait. You have to give time for the court to sign the order. Please wait. Yes.
Well, may I be permitted to mention item number 579 of today's list, my lord? This matter, my lord, I'm paying, my lord, there is no likelihood of taking up this matter today. If your lordship, my lord, keeps it as to be mentioned for extension of the interim order, because my client, my lord, approached the division bench against your lordship's last order, and then the court, my lord, asked my client to make an application before lordship's court, and that application has been made, and the
For what?
honorable judge, my lord,
No, the application is for what?
for representation of my case, because I challenged this order, my lord, regarding that passing of the order with the direction in a contempt matter, directing the police, my lord, to get the premises vacated with the force and other things.
Hmm.
Then the court said, my lord, that you make an application before, and the court, my lord, granted and stay order, directing the Bali municipality not to take any cautious stays for 10 days.
Hmm.
Therefore, my lord, that will, my lord, up to, my lord, 23rd, possibly 13th of August, order was passed.
What will this bench do?
No, the court has come, my lord, direct us to make an application in the contempt matter. We have made an application.
For what?
For order, my lord, for the purpose of this order, that the parent order was not, my lord, while the Bali Municipality passed an order, that the hearing was not giving to my client, number one. Number two, the order, my lord, which was initially passed by a lordship, my lord, to consider and dispose of the matter, that was decided by taking a particular decision. Then subsequent decision, rather, my lord, we question about that the passing of that particular order in a contempt matter, my lord, which, my lord, cannot be passed, my lord, in the contempt matter. That is the basic, my lord, the reasons for making that application. The court has said whatever you got to say prima facie, you go to the court of the particular court and make your representation by an application. Then after that, we will be looking into the issue. Then therefore the court has, my lord, passed. We have made an application, and that order which has been passed by the court, my lord, granting that, my lord, the asking the Bali Municipality not to, my lord, take any step for 10 days. That will, my lord, since it will, my lord, expire on 23rd, possibly, my lord, 13th of August, the order was passed. That is the reason I am submitting, my lord.
Which is the item number?
579.
Who is your other side?
নাম দা বলো না কারা কারা আছে Mr. Abhishek Haldar and Oyan Banerjee, Bali Municipality, Abhishek Haldar for the respondent number 1.
Give notice to your other side. Come after.
Yeah, my lord,
That is your problem. I do not know. Give notice. Yes.
My lord, when it will be taken up by lordship, my lord?
After the regular matters are taken up, thereafter.
Lordship, may item number
Well, if you listen to consider, my lord, I am to leave the court, my lord, today by personal reasons, my lord. I know, my lord,
The applications are taken up once in a week. If you are not there, somebody else
if you
will
lordship,
take it on your behalf.
takes it out tomorrow, my lord, the first sitting, my lord. If you lordship kindly, my lord, just my lord, humble prayer before lordship, my lord. Otherwise, my lord, I could not have, my lord, request to lordship because I used to stay in the court, my lord, up to 5.
I know that you stay in court. So this is nothing new, and you also know the practice of the
kindly
court.
consider, my lord. I know, my lord, but this is a case, my lord.
Done.
Possibly, my lord, I require to be represented by my client to address
Then
your lordship, whatever
Thursday it will appear.
my lord.
Next Thursday it will appear.
But the only thing, my lord, because that order your lordship, my lord, staring at his face, my lord, that is the difficulty.
If it is staring today or next Thursday, choice is yours. Yes.
information item number 496 of today's list.
Yes.
Restoration application, Lordship. I have served the.
Nothing. Yes.
Item number 50.
No, nothing. Yes.
Item number 507 of today's list, Lordship, for upgradation, Lordship. It's a restoration application, Lordship.
Yes.
The urgency is that, Lordship,
In a restoration application, no urgency.
May I then
Think
pray,
for
my lord,
leaving this-
may I then pray, my lord, next Thursday, your lordship, my lord, fix up the matter so that I can give notice to my learned friend at some
Item number
579.
579 next Thursday. Top.
Lordship, I'm praying for leave
At the
this
top, my
matter.
lord, your second.
I'm challenging the state administrative tribunal function. Lordship. There is only administrative.
I didn't get
I'm
it.
challenging the state administrative tribunal functioning of the state administrative tribunal, Lordship. There is only administrative member has been taken up the several matter, Lordship, but there is no judicial member.
But
Despite
why
having
will be it taken up before this bench?
but this is purely restitution. So I'm challenging the functioning of the administrative, Lordship.
Some order must have been passed. You are challenging what?
Challenging the advertisement. There is a mention to within 1 year you have to appointment the judicial member, Lordship.
Yes.
There is nothing.
Who has passed order that within 1 year it has to be did? It's a division bench's order.
No, Lordship, the additional chief secretary. No implementation of this advertisement, Lordship. Till now,
What-
only administrative member continue the matter, Lordship.
Oh, so all right.
With
No, Lordship.
Next Wednesday it will appear. Serve. No.
Pray for upgradation for restoration application, my lord.
No, I am refusing prayers.
Can I mention one matter? To mention one item number 30 in today's list.
13.
30.
Yes.
30. Actually, my lord, this has been your honor, my lord passed this order on 2nd August 2025 and directed to release the item in 6th August 2025. But matter is in daily list, but unable to hearing concluded. Oh, and lower court hearing date is 30th August. So, my lord, if kindly fix any days in next week, this will be very helpful.
I am
My
not
lord.
able to follow your submission.
Obviously, my lord.
What? 30 item 30.
Item 30.
Which list?
In Delhi list.
What is the name of your client?
Shama Sarkar.
Shama Sarkar Pal.
Yes, my lord.
আজকে নেওয়া হবে তো এগুলো? The matter is there in the list. It will be taken up. Call the list, please.
My lord, with Miller's permission, can I mention one matter, my lord? Item number 585, my lord. It's a contempt application, my lord. Despite the order passed by this learned court, no reason order has been passed, my lord, till date, my lord. And the private respondent are engaged in, my lord, unauthorized construction, my lord.
Leave it.
And my lord,
Yes.
kindly
Nothing
taken
doing.
up, my lord, today.
Item 381, my lord, contempt matter, my lord. I shall, Mr. Bimal Kumar Sai is appearing, my lord. I shall inform it be taken at any time.
No, no. today
My
it
lord,
will
I
not
have already informed the other side, my lord.
Item number 1.
Item number 1.
Yes. Is it appearing for the first time?
Yes, ma'am.
All right.
There is a violation of the order passed by your lordship on 17th May 2024.
We will solve.
Okay.
The order passed by the court on 17th May 2024 has not been complied with. Stop. Let notice. Now let copy of the contempt application be served upon the contemptor. Release the matter on 15th September 2025. Pendency of the contempt application will not stand in the way of the contemptor to comply the order passed by the court.
I beg to appear on behalf of the petitioner, my lord.
I am appearing on behalf of the respondent number 6.
6.
My lord.
Number 150.
1, 2, 3.
My lord, examination conducted by the Public Service Commission. Then lordship knows, my lord, everywhere the lack of transparency and all this. I have filed one application under RTI Act, Annexure P7, thereafter first appeal, thereafter second appeal. Second appeal is still pending, my lord. I am seeking, my lord, the direction upon the second appellate authority to look into the issue, my lord. Certain question you have raised, which is not within the four corner of section 8 of the RTI Act, exempted category.
Did they refuse
We have filed it, but they are sitting tight.
No reply.
No reply. Lordship will kindly come to my lord. Second appeal, my lord, addressed to Chief Information Commissioner, Annexure.
What are your queries?
Well, the queries, I'm just kindly come to Annexure P11, page 35, is my second appeal pending before the appropriate authority. My queries are, my lord, lordship, kindly come to my lord, my questionnaire, that is Annexure P7. P7. My lord, Annexure P8, page 28. Is there any specific
was conducted?
rule?
Examination was conducted when?
My lord, examination conducted, my lord.
2021?
Yes. And I have been listed, my lord. Bhaibabusi was taken place.
Yes.
And I belong to, my lord, the OBC category, non-creamy layer. My lord, my question, page 28, is there any specific rule in WPSC regarding how many times a candidate will be called for interview? Lordship knows, my lord, 1:5, 1:6, my lord, the ratio possibly he wants to indicate. If yes, please mention the ratio. Otherwise,
so how many times a candidate will be called for?
Question is, my lord, ratio, my lord, the written test.
What you are submitting and what the question is not the same.
True, my lord, but the application applied by the petitioner himself, my lord, maybe, my lord, the ratio possibly indicated by the second line, it is clear.
Try to understand. You will not be there to make it clear to the authority what the query is. The query is how many times a candidate will be called for interview. That means how many chances you will get.
Then my second question. Please, no, my lord, the chances, so far the age is concerned, one is permitted to, my lord, apply up to his, my lord, the last age.
Right.
That being the situation. Chances is not the factor.
First question
possibly he wants to
require any
get the
answer.
ratio. Please provide me the interview marks
otherwise
of all candidates.
Please mention the ratio. Otherwise, please provide how interview list was prepared. Please mention the ratio. I cannot understand. I do not
my
know
lord,
what
the question
authority
number
will
1 is
understand.
to some extent, my lord, rather problem is there. Please two, my lord, kindly looked into. Please provide me the interview marks of all candidates who appeared in interview. So that is very, it's a question of transparency, accountability. They should disclose it in their website.
As marks obtained on the basis of interview.
Experience, personality, academic career, academic record. So please provide me what is the weightage given for interview performance, experience, personality, but transparency, out and out.
Then, do you not think all these things should be there in your eligibility or the mode of
No, my lord,
selection?
this was not available. My lord, let it be, my lord, relegated to the appropriate authority to look into the issue. If it is within section 8, if it is to be disclosed, do we disclose? My lord, they are sitting tight. I am before this honorable court for intervention.
19/6/24. Yes. Second appellate authority.
At the end of May, my lord, they have filed the second appeal. We are taking up the matter serially. My lord.
Serially means how long will you take? We are in the end of August.
So
The
Only,
examination
my lord,
is
the
in 2021.
statute says, my lord, 1 chief commissioner and 10 commissioner can be appointed, but we are only 2 members are there.
One occasion I know,
My lord, lordships may direct.
His lordship then was directed, my lord, the chief secretary, it will be viewed very seriously. In the event, my lord, the commissioners are not appointed there. That particular order is lying with me. After that, my lord, some commissioner are appointed. Again, my lord, in absence of Justice Dotto, the situation
But
is...
kindly give us some time. We will certainly. We always give preference to the High Court directions of cases.
You bring the answer to the court.
I am not the custodian of the information.
PSC is the custodian.
No, second appellate authority.
Yeah,
you can get it done from them.
We only, my lord.
Yes, my lord.
No, my lord. But we only, my lord, direct the SPIO to provide the information. That much, my lord, we are, my lord, duty bound under this act, my lord. We used to do that things only. So, my lord, we will hear out the second appeal and we will give directions upon the SPIO.
Keep it pending, my lord. They are trying to, the PSC authority is trying to hide something.
SPIO is
my lord the PSC, my lord.
Yes, lord, Public Service
Page 20.
Who is appealable?
Do we have effected service?
Who was there just now?
It's the appellate site item number 2.
Public Service Commission, who appears?
Well, normally Miss Piali Sengupta appears.
Nobody is appearing today. You can serve a notice and come back.
Unless
so that the information can be produced here in court. Otherwise, you will send to the PSC. PSC will not give a reply.
The same thing, Lord.
The petitioner intends to obtain certain information under the Right to Information Act from the West Bengal Public Service Commission. Step. The information relates to the examination conducted for appointment of assistant professor within brackets civil engineering department of the examination conducted in the year 2021. Stop. The query of the petitioner is appearing at page 28 of the writ petition. Stop. Paragraph. None represents the West Bengal Public Service Commission. Stop. Let further notice be served upon the non-appearing respondent.
Lords.
Stop. Hearing of the writ petition stands adjourned till 4th September 2025. Stop. Learned advocate representing the West Bengal Public Service Commission shall produce the reply to the queries made by the petitioner on the adjourned date.
Deeply.
Grateful, Lordship.
You also communicate to SPIO that this is the query of this is the order of the court.
Great, Lordship.
And in the meantime, if the learned counsel who appears can be communicated, then you can do it.
I will let her know also.
All right, that will be good.
Lord, I'm for the petition. My lord.
Item 3.
Item 3, I'm for the petition. MCPI Private Limited.
Oh, sorry.
My lord, I appear for the petitioner, my lord. My lord, very simple question in the writ petition, my lord, already covered by my lord's order. Question is, my lord, scheme of amalgamation sanctioned by the Honorable NCLT. No immovable property concerned in the scheme of amalgamation itself. Only shares have been issued. So the question is, what is the rate of stamp duty that is to be applied? State says it will be 6%. The collector says it will be 6%. I say it will be 0.5%. If, my lord, I might just take, my lord, through the scheme once. My lord, scheme is at page 35.
Are you ready with your instructions?
I need to file an affidavit because there are two judgments of this honorable court on the similar issue, my lord.
One saying that it should be 0.5%, the other
Diverse judgments.
judgments, and both from both not appeals are preferred, not appeals are pending. So possibly.
My lord, if I may explain on that point once. My lord, the question that I am arguing today before your lordship, that was answered in a judgment of the honorable single judge of this honorable court, Dalgreen Agro. Identical issue answered in my favor. Thereafter, my lord, there was another writ petition which came up, Indorama. In that petition, the question was that properties were situated outside of West Bengal. So what would be the rate of stamp duty payable? There, the honorable single judge has taken a decision that it will not be considered under Article 23A at all of the Stamp Act. It will be covered under Article 23. So therefore, there is some confusion. My lord, being led by Mr. Sarkar.
Also an appeal
You can continue. If required, he'll take
Yes,
up.
my lord. So that is the question in that writ petition. Dalgreen Agro is still pending consideration. My lord, in a identical matter before your lordship, my lord had Justice Sarkar had passed an order staying the operation of the demand.
Yes.
Yes. And my lord,
First এটা তারপর এটা last it.
17th January দেখাবো, তারপর last টা দেখাবো।
Why don't you take your seat? You are panting for breath.
I'll sit there.
Yes.
Thereafter, my lord had passed a similar order in this matter, my lord, and this order has been extended by my lord from time to time. Today, we are asking only for this, my lord, in terms of prayers H and I of the petition. My lord,
This is it is in connection with the same matter, isn't it? 726.
Yes. Yes, all same matter, all same matter.
Yes. Hmm.
H and I.
Where is the order? Let me see.
The impugned order, my lord, relating to the assessment, my lord, is at page 34. That is the collector's order. My lord, 3 paragraphs from the bottom, my lord, the assessment has been made.
%6. This order was passed in February. You have come up in August. Why there is delay of 6 months?
My lord, actually, my lord, there is already but the same question was already pending, my lord. But nothing has happened in that matter till now. So, my lord, we are constrained to prefer this writ petition.
No, but then you could have come up earlier also.
No,
Yes,
one
what
thing
is
that
to
they
be
are asking
done?
for stay. This is an adjudication under section 31. They approached us for an adjudication under section 31. The collector has adjudicated. Now they are asking for stay of this. We cannot not give effect unless they present the document with the stamp duty. We cannot take any further steps. So there is no scope for us to take any further
Yes.
steps.
Right.
We
Even
cannot
I
take any
was,
coercive steps.
I was even wondering what coercive step can you take?
We cannot possibly what they're apprehending.
What is your apprehension?
Well, the apprehension is, as of now, Lordship, no further steps on their part should be taken because
What steps will they take or can they take?
Lordship, if, for instance, I do not have any relief and after a delay, I present my document, well, then I will be foisted with certain consequences. For instance, well, the issue as to which is the correct position of law, Lordship, there are 2 conflicting judgments which are pending consideration before the Honorable Division Bench. Taking cognizance of that, these orders have been passed by your Lordships from time to time in respect of other matters, pending disposal of that issue. Now, Lordship, for instance, that issue may be decided either in favor of the assessee or against the assessee. It may be decided that no, it is Article 23 which applies, in which case I'll be liable to pay stamp duty at 6%. Now, Lordship, if I do not have any protection from the court, but I will be liable to pay that entire penal interest under the Act.
Later
Lordship,
on.
which is why.
2,700. Amount is 2,000.
Yeah, I can see 275.
Malad, be that as it may, as a matter of principle, Lordship,
Right, because
even
today
in
it's
respect,
27, tomorrow it may be higher.
Lordship,
So
which
it's
is why, as a matter of principle, a simple, in fact, in the other matter, Lordship, a submission was made on behalf of the state that we will not proceed with this issue. We will not proceed to assess till the issue is decided. In fact, on that basis, the initial order was passed by Honorable Justice Sarkar. The same submission was reiterated before your Lordship, on the basis of which Lordship passed this order that the issue is pending before the division bench.
all right, please come. The assessment made by the collector of Kolkata, within brackets, stamp and revenue, on 28th February 2025, directing payment of stamp duty assessed at 6% of the total amount of shares transferred is impugned in the instant writ petition. Stop. It appears that a similar issue is pending consideration before the Honorable Division Bench. Stop. In another writ petition on the same point, a coordinate bench of this court, with a order dated 1st August 2024, passed in WPO 726/2024. Party নামটা একটু দেখে নেবেন তো, was pleased to pass an interim order staying the stamp duty assessment. Stop. The interim order is subsisting till date. Stop. Next paragraph. Learned advocate representing the state respondents admits that the appeal is pending consideration over the self-same issue before the Honorable Division Bench. Stop. Next. In view of the above, the impugned assessment order is directed to remain stayed till 19th December 2025 or until further order, whichever is earlier. Stop. The respondents are directed to file their affidavit in opposition within a period of 4 weeks, reply, if any, within 2 weeks thereafter. Stop. Liberty to mention.
Grateful, Lordship. Well, may the affidavit of service be taken on
Yes.
record. Much obliged.
My lord, this matter, Lordship would recall, my lord, the challenge is to the willful defaulters action. On the last occasion, I had shown to your Lordship the show cause notice, and I had shown, my lord, the show cause notice, my lord, quotes the RBI circular 2.1.3, 2.2.1 C, D, and B, C, and D. And then I had shown your Lordship their reply. And my lord, I had primarily contended that in their reply, there is an admission that there has been a willful default in the sense that the definition conditions are satisfied by their admission itself. That is, they have admitted that they have transferred funds to their sister concerns or their subsidiaries. The only explanation was that they have done it by way of a strategic investment and that it is reflected in their balance sheet. Now, I had shown that once you admit that it has been transferred, the definition is satisfied. The bank had said that no permission, written permission is required because essentially it's a case of waiver of condition. Until and unless there is written permission, you can't say that there is implied approval. Now, I had stopped, my lord, in the order of the identification committee. If I start today from there, my lord, that is at, it starts at page 510. 510, it should be, my lord, volume 4 of the Manoj Toshniwal writ. Item 5. My lord, will kindly take item 5, please.
Yes, yes.
Because, my lord, that's the parent matter and I'll come back to the others. My lord, it starts at 510. The relevant portion, my lord, after, my lord, the submissions, my lord, of both the parties have been recorded. I had shown your lordship the submissions of Toshniwal also, and I had shown what was the submission of the bank, which starts at page 517, my lord, from the bottom. The DG examined, and my lord, these were the submissions. Now, my lord, kindly come to 520. The reasons. Because, my lord, one of the challenges is that it is not a reasoned order. What has been done is only a mechanical setting out of what show cause allegations are and only the bank's case, and it's not a reasoned order. That is one of the principal allegations. Now, I have shown your lordship what was the allegation. I have shown what was the reply, which has also been paraphrased and summarized. And this is, my lord, the decision with the reasons. WDC in meeting held on 20th November deliberated on the memorandum and submission made by DG and noted the following. Ex-promoters, directors, guarantors of EMC, well, the names have been given, did not appear before WDC for peremptory hearing even after granting 3 opportunities, last opportunity being given on 20th November. But, my lord, all that written representation, my lord, those issues have been considered. Now, my lord, what's the effect of that? Kindly see, my lord, it's in the reasons are, my lord, these are administrative officers, my lord, officers of the bank, my lord, it's in bullet form. My lord, tick mark lordship will find. No prior written permission for investment in group companies have been submitted. This is the first finding. And in the writ petition, this finding is wrong, my lord, it is not their case. Second, EMC has not shared any evidence of consent of the consortium bankers obtained before availing loans from non-consortium lenders. Again, my lord, this is a finding, and my lord, in the writ, there is nothing to say that this was wrong or it was not from materials on record. 520, page 520. Third finding, my lord, that's the third tick or the third bullet. Investments in subsidiaries were out of accruals or borrowers fund. This is very important because whatever money is coming in, and my lord, this is supposed to be channelized to the bank, and if you, my lord, make investments in the subsidiaries in that, my lord, it's a direct admission that I am routing it to a subsidiary company of mine. The company or directors, guarantors were willfully indulged in investment in other companies by way of acquiring equities and debt instruments without approval of lenders. I have already shown, my lord, they say that they have the money granted was not to buy shares of companies in subsidiaries or make investment in shares. It was for running the business. And this has been done. And none of these findings, my lord, with subject to correction by my learned friend, have been, my lord, challenged in the writ petition that these findings are factually wrong. Then, my lord, the fifth one, the company directors, guarantors did not take any tangible, visible, and material steps to plow back the provided advance investments, thereby allowing the parent company to slip into a non-performing asset. My lord, I had already shown you to your lordship, my lord, even before the consortium, whatever money, my lord, they had said, assurance was given in the minutes, which they have replied that it would be plowed back. That is, it would be brought back to the company. But, my lord, that was not done. And that is recorded in black and white and minutes there. Then, my lord, the next one, the company routed transaction from account maintained outside consortium, and the bank has been mentioned, without prior written permission from consortium lenders. Then, my lord, the next one, Biplab Shankar Bose was a whole-time director and professional executive director of EMC. My lord, this I will deal with when I deal with his writ petition separately. And IDBI Bank never agreed to discharge Srimati Sunita Bardia from her liabilities as guarantor for further cross facilities availed by the said company. Well, this also, my lord, this is the subject matter of the other writ petition. Factually, slight issues are there. I'll come and deal with that, my lord. These two, Biplab Shankar and Sunita Bardia, I'll deal with slightly later. So, my lord, these are the reasons. Now, inadequate reasons, adequate reasons, that's a different issue. But my first submission is that reasons have been given, and these reasons are logical and a probable, any reasonable person can probably come to this conclusion, reasonably come to this conclusion, given the factual background. Given the factual background that the willful default definition itself, my lord, includes an act of diversion to say that by whatever means, if you transfer money to your subsidiaries or associates, it amounts to willful default. And the reasoning is inadequate. The reason to justify is inadequate. And my lord, these 7 reasons are there. Then, my lord, kindly see, my lord, next para. The WDC therefore concluded, para 6, that ex-promoters, directors are, my lord, willful, they satisfy the definition and on willful default as summarized in para 3 above. So para 3 was the allegation, 5 are the reasons, then, my lord, para 7. On perusal of the record and having regard to the facts and circumstances of the case, the committee recorded its findings as follows. EMC has defaulted in meeting its payment or repayment obligation to the lender, and the ex-promoter, director or guarantors, and the names have been mentioned, they are guilty of default. And B is that ex-promoters and directors, Manoj Toshniwal and the others, are fit to be declared as willful defaulter, and the decision of the committee may be submitted to the willful defaulters review committee for confirmation and thereafter for reporting to the credit income. So, my lord, twofold. One is that it be conveyed to them, and, my lord, it be submitted also to the review committee. Now, my lord, kindly see who has signed the order. It has been signed by one of the member of the committee itself. That is, my lord, Murli Sauri Rajan, member of WDC and also authorized signatory. So, my lord, no, and my lord, lordship can take it from me. There is no allegation that it is, well, in black and white it is there, but, my lord, all the members of the committee were present because they did not personally appear. And, my lord, and it has been signed by one of the members of the committee itself.
And is it not required to be signed by all the members?
Well, there is no such requirement. There is no such requirement.
Anybody can sign it.
Yes, well, it's a collective decision. One signs it, my lord. Well, conventionally in our judicial proceedings, my lord, we have, my lord, when it's a division bench or a larger bench, my lord, we have the junior judges.
The judges sign.
Yes, my lord, at least I agree or something is there, my lord. Here, my lord, it has been signed on behalf of the committee by one of the committee members itself. What is falling from your lordship, my lord, review committee, my lord, there may be an issue. I'll make my submission on that. Here, my lord, and that is why, my lord, they did not canvass this so far as this is concerned, because it is by the committee member itself. And, my lord, in our affidavit, my lord, we had also disclosed that he was authorized also on behalf of the committee to make this decision. I'll come to that later. But I am now, my lord, mainly dealing with the prime allegation that it's a mechanically done job, it's a cut and paste job, and it did not contain any reason. That was the principal, my lord, allegation so far as my clients are concerned. That is why, my lord, I tried to persuade your lordship, my lord, that this is how, my lord, the things have transpired. Now, my lord, taking this further, kindly see what was the representation against this order to the review committee. Well, that representation, lordship will find at page 532.
Yes.
Because, my lord, review committee has simply, my lord, upheld the order of the first committee and has not given separate reasoning of its own, and that is one of the allegations. The reason why I am taking through the representation, His Lordship will not find a singular challenge to any of those 7 findings or 8 findings in bullet form. It's a reiteration, or if I may borrow their expression, that it is really a cut-paste job from the earlier representation. Now, 532, Lordship will find in the 3rd paragraph, not constituted in accordance with the master circular. Well, they don't give any further particulars that why they say so. Because, well, committee member, firstly, they don't appear. And because it's a singular signature, they assume that the others were not there. Be that as it may. I am now on merits. Technical aspects I'll come slightly later. Well, kindly come to page 534. I'll deal with the technical aspects later, since I am dealing with 534. It should be the, my lord, 2nd paragraph starting in the instant proceeding. In the instant proceeding, we had filed a detailed reply dated 15th May to the show cause pursuant to the order of the Honorable High Court at Calcutta. The contents of the said reply dated 15th May are adopted as part and parcel hereof. It is stated that the order of Willful Defaulters Committee dated 11th January has completely failed to consider and deal with our contentions mentioned in the said reply. My lord, I have already shown what was the contention and how it has been dealt with. Then, my lord, other than a reiteration, I'll just quickly take your lordship through the paragraphs. Lordship will not find anything new in this. In respect of, when I say anything new, means anything new in respect of the 7 bullets or the 7 findings, that these findings could not have been arrived at, or these findings are erroneous. Quickly, if I take your lordship through that, in at the second last para, which is numbered as number 1, respect of allegation of 2.3b, my reply with respect thereto was not examined. My reply to the first event of default, it was inter alia stated, company has utilized the finance for specific purpose it was given. Well, I'd assume for a moment it was for a specific purpose. Then they'll have to show the purpose was to buy shares of their group companies or invest in their group companies. And my lord, it's really a reiteration. Then, my lord, kindly come to para 2 at page 535. With respect to allegation under 2.2.1c, the reply given by me to the second event of default has not been dealt with. I have specifically dealt with each allegation made in the show cause notice and specifically stated that allegation of company making investment to the extent of 47 crores and increase to 48 crores in the next financial year with supporting documents. I once again reiterate the allegation of willful defaulter is baseless. So and so. Well, it's a strategic investment, but they don't deny it is not their subsidiary and all that. It's a reiteration of that. Then similarly, well, so far as the next one is concerned, well, next para is important at 535. Well, after numeral para 2, the second paragraph, which is not numbered, the company has made investment in company named as Steel and Crane Inc. and Quota of Technology. Sorry, the company has not made investment in the company named Steel and Crane and Quota of Technolines SRL. It is apparent that the bank has not gone through the details of investment. Well, I already submitted. The name was incorrectly mentioned. It will Quota word will not be there. Technolines SRL is there. Only the difference was the difference in name. That's all. And then reiteration, investments are strategic in nature and in similar line of activity of the company, mainly to expand the business and better synergy in ordinary course of business. It's a reiteration. So in the backdrop of admission, it is to my subsidiary and it is to my associates. It's a reiteration of that. Nothing new. Then, my lord, the paragraph starting at page 536. Lord, again, it's a reiteration that it was made over a period of years and reflected in their balance sheets. It's really a copy-paste, my lord, from the earlier reply. Then, my lord, the next para at 536, allegation towards transferring of borrowed funds to subsidiaries and group companies. The WDC not only failed to take into consideration the details, particulars, and specific appraisal notes which specifically recorded such investment to be strategic in nature. The notes are recording that I have transferred to the group companies, merely classifying it unilaterally, it's strategic in nature, my lord. Definition is otherwise satisfied even over here. Then, my lord, lordship can take it from me. I am not troubling your lordship with the entirety. The representation made by Mr. Toshniwal to the order or challenging the order of the identification committee is identical. It's a copy paste of or a reiteration of some tweak in language here and there, reiteration of what was stated at the first instance. And lordship can also take it from me as part of my submission. There is not a single line about any of those 7 bullet reasonings, my lord, because, my lord, they fairly or unfairly accuse the identification committee of paraphrasing what is there in the show cause notice and what the bank submission is. But those 7 reasonings, which are a direct consequence of the top, not a single sentence that no, your conclusion that I have made, these are not my subsidiaries, these are not there. Now, if in this background, my lord, kindly now come to the review committee order at 542. But at 542, I am not troubling your lordship, my lord. The review committee, the facts of the cases have also been summarized. And my lord, lordship will find at 546, last line. 545, I'm sorry, my lord, 545. Lordship will find, my lord, these are the allegations have been, my lord, again taken note of. And my lord, last line are the representation from promoters and erstwhile directors and guarantors by letter of 3rd February 2024 and email of 8th February. My lord, 3rd February 2024 is the letter that I just now showed to your lordship. And that has again been paraphrased. And my lord, it has been summarized. The content has been made more short because it's really a reiteration. That 20% cap and all reiteration. And then, my lord, the observation of WDRC. It may be mentioned that a related party transaction between a parent company and its subsidiaries joint venture shall be made only on terms equivalent to those that prevail at arm's length transaction, and such transactions be substantiated. Proper disclosure of related party transactions between a parent and its subsidiaries may be required as per applicable standards. FINAF to form a view about the effects of the related party relationship. That the investments made in the subsidiary group companies or other corporate are borne out from the audited financial statements submitted by the borrower company for the relevant financial years from time to time, and same has been accepted by them in their reply. Now, this is very important. Merely intimating the financing banks about such related party transactions may not absolve the company or directors from their liability to adhere to accounting standards. Same is in violation of the terms of the sanction. With respect to the argument that the advances investment in group company subsidiaries were within the maximum cap of 20% as per the sanction term, it may be mentioned that no such terms of sanction was stipulated by the bank. Well, it's essentially, my lord, it's a reiteration. But again, my lord, at the cost of repetition, I say, my lord, these are what was considered by the first committee. Again, my lord, comes as a reiteration. It is there. And in the writ petition also, they could not show any clause that there is any 20% cap of cash accruals and all that. But I do not trouble your lordship, my lord, because of the similar nature. Because, my lord, the allegations are identical. And no new facts have been stated in the representation. Then, my lord, kindly come to page 552.
Yes.
General submissions, my lord, made from the erstwhile directors, guarantors, video letter of 3rd February and email of 8th February and March 12th. Well, these have been summarized. I just want to highlight. Well, kindly come to 553. Well, the last paragraph, which is, my lord, Roman clause 4. MKN in his reply has mentioned that there has been no diversion or transfer of borrowed funds to them by the principal borrower during the relevant period or at any point. Further, they were a corporate guarantor to the credit facilities advanced by the consortium to the principal borrower EMC Limited. The lead banker, the State Bank of India, after default of loan by the principal borrower, had taken steps under the Securitization Act, MK and furnished security by way of mortgaging of immovable properties of 6 flats at Avani, Oxford, at premises 136 Joshua Road, Kolkata. The lead bank SBI had invoked invoked the provision security interest, and after taking measures under SAFESI Act, sold all the securities MKN had furnished towards the credit exposure of principal borrower and recovered proceeds and adjusted the same in pro tanto satisfaction of the debt. MKN were thereafter left with no other means of satisfying the debt of the principal borrower, and as such, the question of being show cause, not being a willful defaulter, and as a guarantor of the principal borrower does not and cannot arise. The master circular is not applicable. Now, my lord, essentially, and I'll deal with this in detail when I come to their writ petition, the submission is that my security was sold by one of the bankers, the security which the corporate guarantor had given, and because I don't have any other assets, you cannot show cause me as a willful defaulter, because whatever security was, it was sold. I don't have anything else. Therefore, there is default, but I am not a willful defaulter because I don't have anything more to satisfy the debt. This is in sum and substance what they are saying. But I'll show your lordship, as per the RBI circular, if you are a guarantor and your principal borrower is declared as a willful defaulter, you are also automatically, my lord, brought in under the purview of the circular. And my lord, if the security furnished by you is insufficient, my lord, otherwise also, my lord, in terms of Contract Act, my lord, a surety is jointly and severally liable as that of the borrower. We have no difficulty in this. But here, my lord, there is an element of willful or a deliberate element. And that is why, my lord, RBI recognizes in its definitions all these clauses. Now, my lord, the question will be whether once for the borrower, he falls within the category of a willful defaulter. For guarantor also separately, I have to come and say that no, he is a defaulter but not a willful defaulter. That will be an issue. I just pointed it out. When I deal with the writ petition of that, my lord, I'll make my submissions on that. Now, let kindly come to the observations of WDRC, which is at page 554. Well, at Sunita Bardia, my lord, it was noted. She continued to be a personal guarantor in the account, and IDBI never agreed to discharge her from her liabilities. My lord, I'll show the documents when I deal with the writ petition. And that has been acknowledged by signing the acceptance of the sanction in 20th October 2017. Further, an existing guarantor, her liabilities were coextensive. With respect to the proceedings under Section 95, IDBI Bank has filed rejoinder against the additional report of the RP, reasserting our stand that first, Sunita Bardia stood as a personal guarantor for the loan sanctioned to EMC. Final order is so and so. And then, my lord, kindly come to conclusions of WDRC, page 555. based on the above mentioned facts and analysis, WDRC is of the opinion that events of willful defaults were committed by the promoters, erstwhile directors, guarantors, and it satisfies the clause. And next para, WDRC accordingly concluded that these persons or the corporate entities are willful defaulters. And now comes a formal order. WDRC carefully examined the contents of the written representation received in response to the order issued by WDC and observed that the written representation have not brought out any new fact. Now, this was challenged by saying it's a mechanical observation without even considering that. That is why, I took the trouble of taking your lordship through what the representation was before the review committee. And in pointing out that not a singular new fact has come and no challenge to any of those observations, that these are incorrect because of this. So if that is the situation, with respect, this conclusion is absolutely correct on what is evident from the materials on record. Because all you do in the representation to the review committee is you reiterate what you had stated over there. So what will the review committee do? The review committee has observed what is there, and whatever little minor facts were reiterated, that has been distinguished, and this is the first finding, and in my respectful submission, correct finding, so far as this case is concerned. Written representation have not brought out any new fact or material that has been that has something to do with the carrying of the decision of the willful defaulters committee of the bank to declare them. The responses does not comprehensively cover all grounds on which proposal for declaration as willful defaulter was based. And further, the contents are not supported by facts and records of the account. In view of the above and after thorough perusal of records of the matter and representation received in response to order issued by WDC, WDRC is of the opinion that, and then, the two conclusions are there. And then, last and additional one over here. The order of the review committee is signed by C. Subramaniam and who was authorized by the review committee to communicate the order. I'll come to that. This
We'll
is
come to that on the next.
Yes. I'm sorry, I forgot, Lordship.
No, it's all right.
Oh, it is. I'm sorry, 11:30 has long been passed.
Learned counsel for the respondents continues argument.
Will you continue tomorrow? No, Calcutta. We on Monday.
All right, let it remain in the
Very
list.
well,
Let us see.
Very well.
List for hearing on Monday.
Well, the next matter, if this Mr. Chaudhary seeks accommodation tomorrow, the next matter would be mine, with that MSME matter. So I am also not there tomorrow. Kindly.
Make this prayer tomorrow.
He was very hopeful that I might continue tomorrow, so he does.
Hidden.
Lordship, I beg to appear on behalf of the petitioner in this matter.
What is the correction?
Lordship, in paragraph number 9, in the last line, it is written, Lordship, self-sale cause of action.
Nothing else? Nothing else?
No.
It is same hobby. SAME. Very well.
নাম রয়েছে ওখানে আগের অর্ডারে রয়েছে
My lord, I am for the petitioners, my lord. When the matter has been settled between the parties, I have been instructed to withdraw the matter. And I am submitting my original instruction.
Give. Learned advocate for the petitioner submits that the issue has been settled amicably in between the parties. A written communication has been given by the petitioner to the learned advocate. Stop. Let the same be written with the records. Stop. The writ petition stands disposed of.
Lord, I am for the petitioner. In fact, this matter was inadvertently filed in this court. The determination is with the Jalpaiguri bench.
Learned advocate for the petitioner submits that the cause of action for filing the instant writ petition arose within the jurisdiction of the circuit bench at Jalpaiguri. Stop. I'll transfer it over there.
As your lordship pleases.
What is the use of withdrawing it? Learned advocate for the petitioner seeks transfer of the matter. Stuff next. Let the file be transferred to the circuit bench at Jalpaiguri.
My lord, an amendment may please be allowed. A supplementary evidence, because on the top of the petition, I have written Nodia inadvertently. That's how actually the mistake was there.
Be granted to the advocate on record of the petitioner to amend the.
For a supplementary evidence through which.
Why supplementary? Here and now amend it. To amend the front sheet. And the initial pages of the writ petition wherein the name of the district has been incorrectly mentioned as Nodia in place and instead of Kuch Bihar.
That should be enough. This item number 2. I am appending on here for a phone number 32123.
You are not there.
My name is Ekhoda. Actually, I am waiting for another.
দিয়ে দিন তো নামটা। Next.
I will maintain the same stand. The application also does not show that there
It
is.
has to be released.
But as on date, writ petition is practically infructuous because the only ground was that the FIR has been closed, so the ECIR PMLA proceeding should not go. Now the FIR closure order has been stayed. So as on date, the writ petition became infructuous unless this in the CRR, the closure order revives. So there can be two options. They will wait for the outcome of CRR or the writ petition will be decided on merit.
My lord, may I say?
Prayer is opposed for release.
My lord, they have the right to oppose, my lord. But the issue is that in the writ, what was our prayer? The main prayer, we have prayed for quashing of the ECIR that they have registered. In the two divisions, what they have prayed, they have prayed for revival of the FIR. So today, my lord, if they succeeds, my writ petition automatically become infructuous, or vice versa.
So let it remain pending.
Correct. That is
why?
my
What is the use of transferring it or releasing it?
My issue that the revisional court is already in the session of the.
Let it remain in session. Since there is an opposition, you see what happens to the CRR, and then any order that will be over there, it can be taken note of in this matter. What is the use?
My lord, only my.
Please come.
My lord, only one thing. My lord, only one thing.
The petitioner prays for release of the matter from the list of this bench.
My lord, only one thing. Both can be decided
to tag the same with the criminal revision application. Step paragraph. The aforesaid prayer of the petitioner is opposed by the learned advocate for the respondents. Step paragraph. As the petitioner submits that the matter is related to the criminal revision application, Let
Well, the
the
subject matter is the same, my lord. Kindly record that.
আচ্ছা এই লাইনটা কাটুন আপনি লিখুন
Subject matter is
Learned
not
advocate for the petitioner submits that the subject matter of the criminal revision application and the instant writ petition are the same. Stuff very well. In such circumstances, the order passed in the criminal revision application can be taken note of in the writ petition when the same is taken up for consideration by the court. Next.
Well, the application may be disposed of.
The application
No,
is for
let the
release.
application be
for
pending.
release.
Well, let the application be pending. Why it should be disposed of, my lord? It's subject to the final
Application
outcome of the criminal review.
Can
No,
one
no,
stand
application is not
disposed of?
Writ is
But kindly do not dispose
Writ
of
is
that.
remaining
Writ
pending.
is pending.
The writ is not disposed of.
Yes, that I have understood,
Then
my lord. What I have fallen from your lordship.
5.
My lord, kindly give me the liberty to mention then. I can
Liberty
have
to
the liberty.
mention. Yes, liberty to mention upon notice to the respondents.
Very grateful, my lord.
Lordship, are you happy for the respond number 1 to 4?
I'm for the petitioner, Lordship. Lordship, the interim order is expiring on 29th of this month.
What is the position? Your opposition is there?
It is with regard to a fraud classification by the bank.
Yes.
Now, there without that has been stayed by a coordinate bench. Now, we have filed a opposition, it is ready for hearing. Reply has been filed. If you not
Lordship, if I may hand over my reply, copy has been served.
Yes, please come.
very short matter, whether addendum has been served upon them, that is the only issue.
The affidavit in opposition by the respondent bank and the reply thereto by the petitioners filed in court today are taken on record. Stop. The matter is ready for hearing. Stop. It will be open for the parties to mention the matter for hearing before any other honorable bench having determination. Stop. For the time being, the interim order that is subsisting in the matter is extended till 19th December 2025 or until further order, whichever is earlier.
Grateful, Lordship.
So I appear for the petitioner. May I file
Yes.
affidavit of service?
My lord, I am for the state, my lord. My lord, led by the government pleader, my lord.
Will you represent the Mushidabad estate also?
No, my lord.
What no?
I cannot go. So in that case, I just received this.
Government leader as well as Mr. Mandal is leading us in this matter. In these matters, Mr. GP and additional government leader, Mr. Mandal is also leading.
Mr. Ansar, all were there.
Mr. Ansar is
He will be coming, my lord.
All right,
now,
let them come.
the thing is, it was with regard to tender of a ferry ghat. It was invited by the judicial department. On behalf of the judicial department, estate officer issued the tender. Lordship, the tender specify, the tender is at page 23 of your lordship's brief. The name of the ferry ghat so and so, base rate 30 lakhs. So I quoted over and above 30 lakhs. I was given permission. Lordship, kindly come to the next page. The vehicles which were allowed to be carried on by the country board. Lordship, page 24, the bottom, passenger with cycle, motorcycle with passenger, four-wheeler including driver. Next page, van rickshaw loaded, van rickshaw unloaded. That's were permissible in carrying on the country-made boat. Now, this tender was subsequently the LOI issued on page 26. On 2nd of September, I was allowed to permit from 1st November to 31st of August 2025. This work order issued on 22nd of September.
Not 22nd,
2nd September. It was from 1st September. Now, when I submitted or quoted the bid amount, I was under the impression that in terms of the tender, I would be allowed to carry those particular vehicles. Immediately after issuance of the work order, Lordship, kindly come to the next page, page 27. It was issued by the district magistrate, thereby restraining from carrying the four-wheelers. Now, so far tenders specify that I will collect the most levy from the four-wheeler. Four-wheeler was restricted. In spite of that, I continued because there was an accident took place. For that reason, this particular restriction was issued. In spite of incurring loss, I continued my operations. Lordship, kindly come to the next page. I am
basically agreed by this page 28. By virtue of this order, it was issued on 17th of July, the van rickshaw, that was also restricted. Now, Lordship, I have incurred so much loss for carrying out this entire, I have only 31st of August for transporting or carrying on this operation. Now, on the verge of completion, this restriction was issued.
Yes.
So I'm
What can be done? Maybe for the safety and security of
for
the
that reason,
passengers.
four-wheeler was restricted.
Now,
in
van
spite
has
of
been
incurring
restricted.
loss.
There must be some reason for.
No reason has been stated.
No, must be there.
My lord will kindly see the photographs of the. It's not possible, my lord, that four-wheelers can go when it can.
Even Lordship,
This ferry, my lord.
Where are the photographs?
Lordship, prior to that, next tender for the next year has been issued. In that also, the van rickshaw has been permitted. Now, so there is, if there is any endanger or safety or security for the subsequent period, because this tender was issued after the order, prohibition order issued by the district magistrate.
Where is the difficulty? The vans are going.
The subsequent tender.
Normal vans, my lord. This normal. These are the bike-driven big vehicles carrying the luggages. These are not the ordinary vans, my lord.
You can limit the weight.
Yes, that can be done. That can be done.
Lordship, kindly, this is the subsequent tender for the next year from 1st September 2020. Here also they have allowed van rickshaw. If there are any danger, they ought to have removed this.
What you want?
No, Lordship, kindly permit me to load the van rickshaw because only limited period is only about 10 days. I will be allowed to operate.
Who will take the responsibility if something happens? The monsoon season, the river is
Lordship,
absolutely
in terms of the order of the district magistrate on
swollen
5th
with
of
water.
September, every precaution has been taken. If your Lordship kindly come to page 27.
Why don't you approach the authority for relief?
Lordship, I have submitted representation at page 30. Immediately thereafter, I submitted, but nothing has been happened. I am incurring loss.
Very well.
Because I have paid the entire bid amount.
Van rickshaw, how much is the rate?
Lordship, in the subsequent tender, it has been quoted 15.
15
And in
rupees.
terms of the earlier tender.
And van rickshaw, it's loaded. Van rickshaw, it's unloaded.
15
How do you say that you're going to restrict? Because you are permitting loaded van rickshaws.
Photographs are in respect of adjoining ferry ghats where it has been permitted. The case is that because nearby these kind of vehicles are being allowed, the restrictive measures have been imposed on certain ferry ghats, not on that one. This one
The
is
petitioner is permitted to carry? No.
not in respect of the Dahapur ferry ghat or Dahagat ferry, the Ishaganj ferry.
But in respect of this particular ghat, Lordship, the subsequent tender specifies.
Ichaganj ferry ghat.
Ferry ghat is the petitioner's ferry.
Yes. Is the petitioner permitted to carry?
No.
And then you have fixed a rate for the loaded rickshaws, van rickshaws to be taken, and then you.
That was in the tender notice. Kindly consider the accident occurred in 2023. The tender notice was floated in 2024. This is a, as your lordship also understands, this is a standard format.
No, in that case, the rate of rent should be reduced. This is what his prayer is. Nothing more.
No, that is not his prayer.
It is exactly his prayer.
Your lordship kindly
because I have incurred loss
SPO
for a
order
year.
Was there in September 2024. DM order has come up in 16th July 2025. He has got only 10 days remaining in his tenure. So this is kind of a belated writ petition with the apprehension that by filing this writ petition, I'll be
belated
getting an upper hand in the next.
Lordship, the order was issued on 17th of July.
That's the DM.
And I have, yes, prohibiting the van rickshaw.
And your lordship kindly
17th of July, this order was passed.
The purpose of section 152(1), it is about controlling nuisance in river or in carriage kind of permits to secure the public life. It is for the greater aspect, your lordship. Your lordship, if
greater aspect in the notice inviting tender, you have permitted it.
Your lordship, it was not permitted. The rates have been given.
That means you are permitting. Otherwise, how can the rates be given?
Even for the next year, also it has been permitted.
The accident has occurred, my lord. A vehicle was.
Accident occurred in 2023. Tender was issued in 2024.
Ligunto, the petitioner.
Please this judgment, your lordship.
No, please don't. The petitioner is running the ferry in Ichaganj Ferryghat pursuant to the order issued by the Estate Manager Murshidabad Estate on an Murshidabad Estate stop. The contract is valid.
So kindly indicate judicial
Ordered
department.
from Murshidabad Estate within bracket judicial department. The contract is valid from 1st September 24 to 31st August 2025. Stop. The vehicles which would be permitted to be ferried were clearly mentioned in the notice inviting notice inviting e-auction. Stop. 4-wheeler including driver and van rickshaw within bracket loaded were permissible. Stop. The petitioner submitted bid relying on the terms and conditions as mentioned in the notice inviting e-auction. Stop. Due to safety reasons, the 4-wheeler including driver and thereafter van rickshaw were prohibited from being ferried. Stop. Paragraph. The petitioner submits that the petitioner had to incur losses for not being able to carry the vehicles which were permissible in terms of the notice inviting e-auction. The petitioner made a representation before the Estate Manager Murshidabad Estate. What have you mentioned in your representation? What is your prayer?
So I have stated that we have, because of this prohibition order, we are suffering financial loss.
Yes.
So kindly allow us to permit the 3-wheelers, which was there even in the subsequent tender, they have permitted 3-wheeler van rickshaw.
Petitioner made a representation before the estate manager Municipality Estate.
Seeking permission to ferry the van rickshaws. Stop. The same was, the aforesaid prayer was made particularly in view of the reason that the subsequent notice inviting e-auction permitted.
No, Lordship, kindly, because this representation was submitted prior to issuance of the tender.
Oh, acha. কি বললাম তাহলে?
The aforesaid prayer was made particularly in
না, particularly viewটা কেটে দিন। আপনি লিখুন, it has been submitted that the subsequent notice inviting e-auction floated by the
same authority, estate manager,
same authority has permitted ferrying of 3-wheelers. The petitioner prays that the authority permits the petitioner to ferry the 3-wheelers so that the petitioner can recover some of the losses which the petitioner had to incur for not being able to carry the vehicles. Stop. Paragraph. Learned advocate representing the state respondent submits that the restriction had to be brought in, keeping in mind the safety and security of the passengers. Stop. Paragraph. There is no explanation by the state respondents as to why van rickshaws have been permitted to be ferried in the notice inviting e-auction that has been floated for the year 2025-2026. Stop. Paragraph. In view of the above, the instant writ petition is disposed of by directing the estate manager, Murshidabad Estate, Judicial Department to take a decision on the petitioner's request for ferrying 3-wheelers for the period the the contract is existing between the petitioner and the respondent authority. Stop. A decision shall be taken in the matter at the earliest, but positively by 24th August 2025. Dispose statement of facts kept with the record, service is taken on record. Next.
But may I just add one thing? The authority will act on the basis of the communication.
Parties to act on the server communication.
The respondent number 7.
On behalf of the state respondent. This going.
Yes.
Milord, may I file my report, Milord?
Yes.
Report. Exception file.
We get a copy of the exception that you filed.
Respondent number 7.
No, our stated respondent.
He is the right on person.
But we've not been favored with a copy of the exception.
আপনি করতে পারবে না পারবে না আপনি করবেন
Your exception.
Yes.
What does the report say?
The kindly takes up below the report. It's very interesting report.
Yes.
Kindly come to page 4 of the report. What is the report? And they have given a tabular chart at page 5. The grievances, suppression of fact. Milord, one thing may I remind your lordship, Milord, your lordship's pleasure was that, Milord, we should file a very, very short report. That's why, Milord, I have filed a very short report.
You must have included all the necessary facts.
Yeah, I have included.
Then what?
I have included, Milord.
Yes.
Milord, their grievances and our redressal.
Let me see.
Now, when my grievance or suppression of fact, finding is despite the bidder withholding information about their current work in hand, therefore my allegation is proved. How did they justify is fantastic. Yes. The existing commitment of the private respondent number 7 was pre-considered. In technical evaluation, as private respondent number 7 was awarded one number of work lies under WBSRD Birbhum division within this department. After considering the existing commitment, the private, how do they get it? Because it is our department's work. They are currently
your department.
Yes.
Therefore, you had done a research work to find out what is there in favor of the respondent number 7. Then kindly come to 2, bid capacity calculation. The bid capacity calculated from this end based upon SBD clause. The redressal, as bid capacity calculation has been conducted by this and during the evaluation based upon clause 4.6. So the complaint remains unsustainable. Now let us see what is 4.6. That is at page 37.
Yes.
The bidders who meet the minimum qualification criteria will be qualified only if their available bid capacity for construction work is equal to or more than the total bid value existing. Maintenance, the available bid capacity will be calculated as per the such and such. Then the maximum value of civil engineering works executed in any 1 year during last 5 years updated to the price level of the last year, there are so and so, taking into account the completed as well as works in progress. Where did they get these documents? These documents were not uploaded with the tender documents.
Were they required to be uploaded?
Otherwise, how could they get it? Unless I disclose, they say admittedly in bid document there is nothing. We have searched our department and we found out. Who had authorized you to search your department after the bid documents were uploaded? And then the next. Trade license. Next page.
What is the work in question?
But this is Prime Minister Rasta.
Gram Sadak Yojana, my lord.
Gram Sadak Yojana.
So
Construction of
roads,
work, my lord, infrastructure project.
upgradation of roads.
Yes.
Now, I believe there are two competitors.
Yes.
Myself and the respondent.
Alright.
Now, kindly come to the next page, trade license.
So this is the third call.
This is on the third call, yes, I'm told. Admitted position.
This is second call, my lord. It is not correct. Second call. My officer says it's second call.
Second call.
আপনি বলবেন না কোনো কথা।
Bidder has uploaded invalid trade license.
Yes.
But during clarification, the bidder has submitted valid trade license. Lord, I submit my certificate that I did not qualify. Then say, no, I have got qualified subsequently, therefore I upload this. Then, but as such, no, there will not redressal is as such no clause mentioned in neither in the NIT nor in the SBT containing the qualification criteria for updated trade license. But as the complainant raised, so the complaint raised, private respondent 7 has been asked to submit the updated trade license through mail dated 22nd July 2025 after the bid was opened.
No, Puruna.
After the evaluation is complete. Now, the private restaurant 7 has submitted the uploaded trade license on 22nd July at 3:06 p.m. Upon receipt of the updated trade license. But if this is not favoring a particular individual, I don't know what would really
It has been found, Purun.
after uploading page.
It has been found, দেখুন পড়ুন।
Huh?
1 month prior towards the invitation of the tender.
That's true, but it was not uploaded.
Complete reading is
If
necessary.
but in an application, I have to disclose all my
Lord,
documents.
all technical issues are raised, my lord. They are, my lord, tendering issuing authority, they are the technical, they have the technical expertise, my lord.
A trade license does not require expertise.
But that has not, neither in the SBT nor in the NIT document, that is required.
A tender, a valid trade license
No,
is not required.
kindly see my redressal. Kindly see my trade license. My lord, page in my internal page 6, as no such clause, has your lordship got it, my lord?
Yes, yes.
As no such clause mentioned neither in the NIT nor in the SBT containing the qualification criteria for updated trade license. But as the complaints raised, private respondent number 7 has been asked to submit the updated trade license through mail dated 27 July 2025 at 2:47 p.m. And the private respondent number 7 has submitted the updated trade license through mail dated 22nd July 2025 at 3:06 p.m. Upon receipt of updated trade license of the private respondent 7, it has been found that the trade license has been updated on 10th April 2025, which was 1 month prior towards invitation of tender. From the documental evidence, it seems that the private respondent has not uploaded the updated trade license due to minor clerical oversight.
Oh.
But as per point D,
Probing from the tender document, what are the minimum eligibility criteria? What are the documents required to be uploaded?
Kindly come to page 21.
And prior to that, who filed this report? Superintending Engineer, Mendipur Circle.
Yes.
He is the tender inviting authority?
Yes.
Yes.
So kindly come to page 33, general instructions.
Yes, general instructions.
The bidders may submit bids for any or all of the works detailed below. The source of funds, eligible bidders, the qualification of the bidders. All the bidders shall provide in section 3 forms of bid and qualification information, a preliminary description of the proposed work schedule, including drawing so and so. Bidders should have valid registration with employees provident for organization under EPF and Business Provision Act. All bidders shall include the following information and documents with their bids in section 3. Copies of the original documents defining the constitution of legal status, place of registration.
Trade license is not there.
আমি বলিনি
হ্যাঁ বলুন
তুই বলবি ওদের বললাম আপত্তি নেই কিন্তু আমাকে শেষ করতে
ওদের না গভর্নমেন্ট
legal status, place of registration, principal place of business, written power of attorney signatories, bid to commit the bidder and valid GST. Total monetary value of civil construction works performed, each for last 5 years, which was not uploaded admittedly, subsequently they got it. The evidence of ownership of major items of construction equipment named so and so. Evidence of arrangement of possessing them, hire or buying defined. Details of the technical personnel proposed to be employed. Reports of the financial standing of the bidder. Evidence of access, credit, and availability for other financial resources. It's authority to seek references from the bidders, bankers. I will show this is also interesting. Information regarding any litigation or arbitration. Proposal for subcontracting. Joint ventures, I am not troubling, my lord.
Where is the clause where the trade license is to be uploaded? Is there anything there?
But that is only not necessary for the purpose of the credibility. Initially, they say they has to show their all documents, copies of original documents defining the constitutional legal status, place of registration. That relates to the trade license. Unless you have the trade license, how can you run the business? And kindly turn to page 41. They require, my lord, the PAN, contractor registration, annual turnover, affidavit regarding corrective certificates, any other document as specified in the state bid documents. Now, trade license was specifically not mentioned, but when it was pointed out, why did they ask for it then? They could have said it's not necessary at all. And then they kindly come to banker's certificate. This is very interesting. Kindly turn to page 124. The banker's credibility certificate would be with the bid document. Now, this is the certificate they have used. Kindly have a note. Page 124.
Yes.
Find out without who had issued and what is the date. When was it issued?
Private respondent is Mondal Stone Product Private Limited.
Yes.
All right.
Then can you see?
Upgradation of road. Such and such.
Upgradation of so mentioning this particular job.
This job?
Yes. Is awarded to the, if it is awarded to the above firm,
we
shall be able to provide
overdraft
credit facilities to the extent of 100 lakhs to meet their working capital. So this is not financial, what is certificate? And not who has signed this and when is this, when was it issued? What is the date?
No date is mentioned.
Nothing is there.
And
document.
What is the requirement in terms of the contract?
Well,
the tender document?
Worthiness.
Yes, financial worthiness. Where is it?
That is your page 41. No, financial. Actually, I just read it.
At which stage did you go out? At which stage did you go out? Technical.
No.
You couldn't participate.
Technical evaluation.
Oh, he is the L2.
Wait. After L2, the financial bid was opened after my objections were raised. That I say that at the technical bid level, he is out because he doesn't have these documents.
All right.
That's why this directed them to consider.
Right.
And the consideration was clearly admission that there was lack of documents.
All right. Yes.
And it turned to the page 4.6, page 36.
36. Which portion?
Yes, we got the clause A. 4.6 assessed available bid capacity. 36. That should be calculated on the basis of this.
I didn't get it. Page 36.
Page 37.
37. 4.6. Bidders who meet the minimum will have. Yes.
Only if their available bid capacity for construction is equal or more than the total bid value executive maintenance, the available bid capacity will be calculated as under. Here, Losh will find that maximum value of civil engineering works executed in any 1 year during the last 5 years, updated to the price level of the last year, so and so taking into account the completed as well as the works. The number of works completed, no financial bid credibility, just.
Yes.
Just give me a second, Lord, I shall show. Yes, page 34. With that subclause F of 4.2. Reports on the financial standing of the bidder, such as profit and loss statement and auditor's report for the past 3 years.
Not there.
And that then, my lord, the authority to take reference on bidder's bankers, age. Now, bidder's banker, my lord, is at page 1.
Past 3 years auditor's report is not there.
That is there, my lord.
Allegation is not there. Well, it's just to nudge me out.
Yes, my lord,
Because you
sorry.
cannot find a single clause.
Yes.
Let
Yes.
Page 1, my lord, page 122 is the, my lord, certificate of the chartered accountant.
122.
This again, my lord, I don't find is dated document. This is undated document. Can you see, my lord, what they're mentioning? 23, 24, 22, 23, 21, 22. Therefore, this is for calculation of the value of A. And A, Miller, I have just placed before lordship.
Clause 4.6.
Then the maximum value of projects that have been undertaken during the financial year 2021 out of the last 5 years, and value there is 46.80 crores. Net worth of Mundal stores is 51.92 crores. But this is again an unsigned document. I mean, without dated document.
No, but then it is only the report. There is no figure mentioned as to this should be. No, in the requirement also there is no requirement.
If the chartered account issues, he must have a date.
He must have a date.
When was he issued this?
All right. But then these are very minor things. You are the L2, so.
No, I L2 I did not approach after coming L2. I had approached the court when the evaluation was made without violation of technical guideline.
Right. Now they have considered and they say that is all right.
And considered, and kindly see, consideration is absolutely beyond the provisions of law. They admit that there was no certificate, no updated certificate.
Now these are very technical things which the court will not go into. There is nothing apparent or to show that there has been gross errors or something. Please come.
But this amounts to gross error, Miller.
The report in the form of affidavit on behalf of the respondent number 6 and the exception thereto filed by the petitioner in court today is taken on record. Stop. The petitioner contends that the objection raised by the petitioner was not considered by the authority in accordance with the tender document, comma. The learned senior counsel for the petitioner has taken the court through the findings of the to the findings and the redressal as disclosed in the report. Stuff. Next. Upon hearing the petitioner, it appears that the findings that has been arrived at that the findings and the redressal that has been arrived at by the executive engineer are too technical in nature. Stop. It does not appear that there is any violation of the principle of natural justice or any error in the decision-making process. Stuff. Next. In view of the above, the court is not inclined to exercise jurisdiction in this matter. The writ petition fails and is hereby dismissed.
Kindly record the report and the exceptions are written.
Next.
Yes. For the private respondent, my lord, before my learned friend starts making commission, my lord, the maintenance of the to be.
Yes, please.
In the instant case,
the petitioner took a loan from the
Point of law is whether the respondents can take possession of the property when the settlement talks are going on. Is this your point of law?
There must have been, but this is one of the
One of the points.
Madam,
Settlement talks are going on.
yes, ma'am. That is what I was submitting.
They failed, madam.
Madam, may I, before my learned friend,
Yes, sir.
may I indicate the facts of the case, madam. Madam, the petitioner took a loan of around 13,90,000 from the respondent company. It is a NBSC, non-banking financial company. We took a loan. There was some discrepancy in the payments. Later on, madam, we resumed our payment. 13.2 notice they issued. We replied. 13.4 notice they issued. Thereafter, they had initiated proceeding under section 14, my lord, for taking possession of the property. My lord, on page 34, my lord, would find the order passed by the appropriate authority, my lord, wherein it was directed that they can take possession of the property. Now, this order was communicated to us in the month of May, indicating that on June, my lord, they would come and take possession.
Yes. Carry on.
My lord, they would come and take possession of the property. But as soon as the petitioner comes to know of this, he goes before the NBSC, my lord, expresses his desire to settle the accounts. That is why, my lord, in the month of June, he makes a direct payment of rupees around 7 lakhs. My lord, may I just...
No, what is your prayer?
No, what is my prayer, my lord? My lord, today, but in the second half, my lord, quarter to 2, my lord, they would come out and take possession of my flat. I say, my lord, according to these terms, settled, there 13,60,000 was the final terms. That was agreed upon. There is no written, there is a verbal consent to it, and that is why we are paying on that money. But today I am ready to pay around 5 lakhs. Let them not take possession of my flat. I was only able to. And why I am not before the DRT? Because section 17 clearly indicates, my lord, I have 45 days from the date of the order to approach the DRT.
First, tell me how the writ petition will be maintainable against a private bank, non-banking financial corporation.
Yes, my lord. The order of possession has been taken by the order that I might have placed 23rd of March, 23rd of April 2025. That is
where is the error? There is no error.
No, there is no error. There is no error, my lord. There is no error. I do not say there is an error.
Then why are
there is been a default in the payment, my lord. We are ready to pay.
What can the court do? You ready to pay? Go and pay.
My lord, they are not willing to accept that payment.
The court cannot force.
Well, cannot force.
You are not challenging the order of the DM. You want a direction upon a non-banking financial corporation.
We had challenged the order of the DM.
Why? On what grounds?
My lord, grounds I must tell, my lord, there is no legal as a ground. But I'm ready to settle the accounts. Well, I'm ready to pay.
The DM will settle.
No, not. He has become functus officio after passing the order.
Against who? What order or what are you challenging? You want?
I'm challenging the order of the DM.
DM, why? Tell me what are the grounds for challenge?
My lord,
there is no ground for challenge.
My lord, there is only one aspect on the grounds of challenge, my lord. If my lord finds page 34, a very technical ground, my lord, it can go against me, it can go in favor. My lord, the CNR number, if my lord kindly finds, not the miss case. My lord, if we track the case on the basis of the CNR number, it shows a 498 case, my lord. I have annexed the details.
Listen, that's something different.
That is a technical.
There's no use going into all this.
Only saying, my lord, I'm ready. There's around 6 lakh around.
What can the writ court do?
My lord, the order is under challenge because they are taking possession.
Where is the order under challenge? The DM's order is not under challenge.
My lord, kindly comes to my prayer, my lord. Kindly comes to my prayer at page 19. Prayer B, my lord.
Is the bank agreeable to take the money? How much are you getting?
Lord, this is.
Has it been sold? Tell me first.
No,
not sold.
The person is to be taken, fiscal person, my lord. Offer.
How much is due?
Presently, it's 9,26,000, my lord. The offer was made by him for one-time settlement. That was accepted for 13,90,000. The first installment was to be paid on June 2025, and the second installment of 8,90,000 was to be paid on 21st July 2025.
Not paid.
No, the company waited till 31st July, my lord. The payment was not made, and the term was specific, my lord, that in the event of failure to make payment, the settlement goes, my lord.
My lord, in June we have paid, my lord. Subject to
Listen, July you have not paid.
have not paid, my lord.
Then
My lord,
what can be done?
I'm ready to pay, my lord. Kindly don't take possession of my property. That is
Ready to pay when?
My lord,
By today.
my lord, by tomorrow I can pay 5 lakhs, my lord. By next week I should
Again? Again, you'll go for installment.
No, by next week. By next week. Kindly stays.
Sir, the
gives
date
me 15
expired
days.
in July. Why will this sympathy be shown to you?
My lord, it's a mercy. It's all of a kind of a mercy petition. I say, my lord, I'm ready to pay around
Go
5 lakhs.
to the bank and
Let them not take possession. Let them take.
showing
My lord,
mercy to anybody.
my lord, let them not take possession. Let them accept the amount.
Under which authority of law will the court stand in the way of the bank of taking
Lord,
possession?
the court cannot stand in it. But when I'm ready to settle the account, when I'm ready to pay the amount,
Settle the bank is not agreeable. The court will force the bank.
my lord, my statutory remedy is gone. Writ court is the only remedy.
It's up to you, sir.
Yes, my lord. But if my lord, if that can be done, my lord, I may not be driven out of my residential house. That is the only thing I'm saying.
You should have taken note of it that it's a residential house. The bank is there to run after the money. Nothing doing. Will you accept 5 lakh today? Today or tomorrow? In that case, it's gone.
Keeps it at 2 p.m. Let her get some instructions.
Total is 9.
Yes, total, because they failed, my lord. Now, as on today, the outstanding is 9,26,000.
9,26,000. How much will you pay today or tomorrow?
By tomorrow, 5 lakhs, my lord.
Tomorrow 5 lakh. Take instruction, because with possession you can do nothing. You have to sell it off an auction. Then only you'll get the money.
Yes,
And here the money is there in front of you. Choice is yours.
Lord, I'll come back with instructions, my lord.
2 o'clock.
No, 3.
3.
2, I mean busy on the.
Doesn't matter. You are not required to remain in the
That is the
between the
engagement.
bank. The 2 o'clock you come.
Well, at 1:15.
I'll let 1:15. That will be better. And 5 lakh today. By today.
By tomorrow.
And the balance.
Well, I'll
4.26.
I'll also take instructions, my lord.
Take instruction.
Again, they will fail. This is the difficulty.
I'm ready to. I'm ready to give an undertaking. By what time they'll fail?
1:15. 1:15.
The 9 is my application.
Respondent number 1 to 5.
The affidavit.
Yes.
Lord, petitioner is a unskilled human resource provider. Petitioner got a contract from the respondents to provide unskilled labor for 1 year. Well, that was a year from 27th of March 23 to March 24. My term expired in March 24. Well, thereafter, the respondents started extending the work unilaterally. First extension was given. I have executed the work. Then second extension has been given.
Written extension.
I'll place it. Just
All right.
after giving a short
All right.
summary, I'll place the document. Second one, I have not worked. Third one, I have not worked. In the interregnum, I gave letters saying that I cannot work for the extended period. My term is over because you have not even paid me properly for the actual term. So I don't want to continue. The moment I give that letter, they give me a show cause for debarment. I reply to that. And then they give me another letter, a more elaborate letter of 2 pages, where they do not suggest any debarment. They say, I will take appropriate action in accordance with law. They cite a few clauses, I'll place all those. I respond to that, and without hearing me, on the basis of my written reply, without considering it, they debar me. This is one part of the challenge, that the debarment is wrong. On 5 counts, I'll show. The other part of the matter is the execution of the debarment, which will be done through the GEMS portal. In the GEMS portal, though this Directorate of Ordnance has debarred me, that's a separate part, they have blocked my entire account. Therefore, now your lordship know that it's a government e-marketplace, all the tenders are through there. I cannot participate in any work. So these are the 2 parts of my challenge. Now, my lord kindly takes the first extension, page 43.
No, show me your earlier contract.
my lord, your lordship will kindly come to. It is starting at page 35.
Yes.
30, 34 clauses are 34 is starting, clauses are from 35 onwards.
Yes.
My lord, kindly take the relevant clauses. First, my lord, kindly takes clause 2.1. That is at page 41.
The period is mentioned there?
No, period, my lord, period I'll show, my lord.
All right, 41, what were you showing?
My lord, period is mentioned at page 34. Period is mentioned in page 34.
Yes.
My lord, your lordship, page 34, your lordship found
Yes.
in the first page, last line, with effect from 27th of March 23. Right? Now, my lord, kindly take the next page. End it.
With effect from such and such till.
Yes, I'll tell you. 36, kindly take 36.
All right, 36.
36. Left hand side towards, kindly take the boxes are there on 36.
Yes.
Kindly take the 1, 2, 3, 4, 5, 6, 7, 8. About 9th box. Tenure duration of employment 12 months. 1, 2, 3, 4, 5, 6, 7, 8.
Second box at the
11th box. 11th box. Or at page 36.
Page 36. Tenure is 12 months.
12 months.
Right.
So my period has expired on 26th of March 24.
Yes.
Now, my lord, kindly takes few of the relevant clauses. Kindly first takes page 41.
Yes.
2.1 at page 41 towards the bottom.
Yes.
Yes. This is the clause on the basis of which they are saying there has been some dereliction of duty on my part. Breach. The purchaser reserves the right to increase or decrease the quantity of the order up to 50% of bid quantity at the time of placement of the contract. The purchaser also reserves the right to increase the ordered quantity up to the 50% of the contracted quantity during the currency of the contract at the contracted rate. Bidders are bound to accept the order accordingly. This is the clause. Why I stress on the word quantity is that they have given the interpretation that the time that they can increase it by 6 months, whereas repeatedly they have used the word quantity. Now, my lord, there another ground is that I have not paid wages to my staff.
All right.
Now, kindly take page 39. The terms with regard to the wages.
Yes.
Kindly take Roman 28.
Yes.
Yes. The service provider shall be responsible for timely payment to take home remuneration of the manpower and deposit EPF and ESI, both employee and employer share, failing which deductions shall be made by the buyer. No debarment, deductions. Then 33 towards the middle. The service provider shall also deposit EPF, ESI of both employer and employee share within 15th of the month of the payment of wages. Then 4.3 Roman 1. As per the contract labor regulations, kindly skip this first sentence. The principal employer or buyer shall ensure that the wages are paid on time to the contract labor by the service provider contractor. In case the service provider or contractor fails to pay the wages on time or makes short payment, the principal employer or buyer shall be liable to pay the wages to the contract labor directly and recover the amount from the service provider or the contractor. Again, no debarment, only recovery. Next, kindly takes page 42. Clause number 3. The participating firms shall ensure that on being selected as L1 through GEM shall not ask any money either directly or indirectly from the casual workers before payment of monthly wages. Such action will be viewed seriously and the incident will be raised against the firm for blacklisting, and necessary communication shall be made to CLC or the Vigilance Commission. My learned senior friend will correct me if I am wrong. This is the only clause with regard to debarment in this contract. Now, my lord,
It is blacklisting.
Blacklisting, my lord, blacklisting and my lord, interchangeably. I am using the word because in my letter, debarment word has been used. My lord, for debarment, there is an entire different guidelines of the Department of Expenditure. But that, I'll argue, will not apply to me because that came into force on 25th of November 2024, as is apparent from the document itself. I'll show it. Now, my lord, these are the clauses according to me, my lord, which are governing my workspace. Now, my lord, kindly takes page 43, that is the first extension.
Yes.
My lord, this is the first extension by which the tenure is extended up to 20, what would this one call? Yes, 44 at 44 up to 31st of May 2024. Page 44, second line. Then page 45 is the second extension by which it is extended at page 45, my lord, clause number 1 towards the middle. Now the competent authority has decided to extend the order for the period of so and so to 31st of July 2024. Then the third extension is on at page 47. Again, clause number 1 towards the middle, where the term is extended to 31st of August 2024. So, in the meantime, there are two letters. I will be candid. I have missed annexing those two letters, one by them, one by me. But I'll still be able to argue my case without it for the time being. Kindly take 49 then, page 49.
Yes.
With reference to the above subject, this is to inform you that the contract was with effect from 27th March 23 to 27 March 24 has already been completed by us successfully. The extended period from 1st June 24 to 31st July 24 has also been completed. Here there's a typing mistake with regard to the date, which we have clarified subsequently. Regarding your contemplated further extension of contract, it is worth mentioning that during the currency of the contract period, you had considerably failed in releasing our bill payment in due time, as a result of which we had to suffer a huge financial loss. The delayed bill payment status is furnished as so and so. In view of the above, we are not interested in accepting any further extension of the above cited contract, and the final bill in respect of the contract is being submitted for your final payment. Also, the formalities with regard to work completion certificate, release of security money would be completed in no time. Then annexure kindly then comes to their reply at page 51. Paragraph 1 kindly takes the last sentence, which is the 3 lines from the above the box. But the salary of the contractual employees, Mulad has got it, Mulad?
Yes.
But the salary of contractual employees deployed for horticulture services, gardening work at the DO Rajarhat complex has been unpaid from 27th May 24 to 31st of August 24. Then the chart they have given, then kindly see page 52. In this regard, paragraph number 3. In this regard, it is stated that your firm was asked to clarify as to why suitable action of debarment will not be initiated against the firm, where the firm will be debarred from all running contracts, awarded bid, participating bids, tenders, future bids, tenders, so and so, and its allied establishments for the upcoming 5 years, along with forfeiting of security deposit. Vide final warning letter dated 17 January 25. Subsequently, an incident raised on Jem Vide incident dated so and so. This 17 January is the document, my lord. We have missed annexing. We have brought it. It wasn't there by the time of filing. We have brought it along with the reply to that. We have it. In the context, your reply, Vide letter number so and so has been received in this office. From the letter, it has been noted that you have cited reference to a previous letter dated 7th of August, wherein you have stated that the service of the total period from 27 March 23 to 27 March 24, 28 March 24 to 31st May 24, and 1st June 24 to 31st July 24 has been completed successfully. However, in letter number so and so dated 27 January 25, you have stated that you are not interested to accept the offer for extension of the said contract after 26th of May 2024, which is contradictory to your claim that the service has been completed successfully up to the 31st of July 2024. So this is the wrong I was pointing out in my earlier letter, that though I have not worked for that period due to the mentioning of that date, they are taking this. Be that as it may, kindly takes then point number 6. That is their main contention. Acceptance, non-acceptance of extended work order. As per terms and condition number 2.1 of the James so and so, the following is stated. Then the clause is quoted. Then kindly skips over one paragraph from the above.
It is the contractual obligation of the bidder to accept the condition of option clause, and hence your claim that this company is not interested to accept the offer for the extension of the said contract after 26th of May 24 is of no value. In view of the above, you are asked to provide a suitable clarification regarding your claim with a letter number so-and-so dated 27 January 25. You are also requested to make the payment to the contractual employee without any further delay. Your reply with proper clarification should reach this office by so-and-so, failing which appropriate action as deemed fit will be initiated, escalated against your firm. There was no specific mentioning that I will be debarred.
Page 52, the very first line.
Yes.
It is stated that your firm was asked to clarify.
Yes, my lord, that letter we have missed. May I hand over the document?
That is the letter.
That is the letter.
All right.
And then next paragraph records my reply to that letter. That also I have brought.
All right.
Those are inter-party. Hopefully, my learned senior friend will not object.
All right, that is coming. Yes.
Yes. Next, my lord, kindly, my lord, my reply at page 54.
Yes.
My lord, more or less, my other replies are there, which I have already submitted. My lord, can you take serial number 4 in that page? Yes. It is accepted that due to oversight and typing mistake, the extended period was written as from 1st June 24 to 31st July 24, which should have been from 27th March 24 to 26th of May 2024. In our letter dated 7th of August 2024, communicated to you in response to your extension letter number so-and-so, we are very sorry for the unexpected mistake from our end. From our official record, next page, from our official record, the period of delayed bill payment were submitted to you vide our letter dated so-and-so. We are not accepting your other points in the complaints under any circumstances. Option clause 2.1 of the contract increases or decreases up to 50% bid quantity does not mean the period of contract, but it means the number of manpower required for the work. Hence, we being the bidder is not at all bound to accept the extension of contract period as is asked for, as you asked for. In view of the cited fact, finally we clarify so-and-so. Therefore, we clarify on the 2.1. Then the debarment comes at page 56. It is regretted to inform you that your firm has been debarred from all running contracts awarded, bid, participated, bids or tenders or future bids or tenders that have been published or will be published by the DOO, that is only DOO, Directorate of Ordnance, and its allied establishments for the upcoming 5 years. This decision has been taken by the competent authority of this office due to non-compliance of monthly wages to the contractual labors deployed by your firm for the period from 27th May 2024 to 31st of August 2024, for which the contract laborers have already performed the work belongs to the service contract horticulture so-and-so, so-and-so, so-and-so for the Rajahat complex. In view of the severity of this breach and violation of service contract, competent authority has also decided to forfeit the bank guarantee security deposit amount made in favor of the principal controller of accounts or so-and-so permanent security deposit as everything forfeited. Therefore, my lord, for not making payment for 2-3 months, for which the contract I am disputing that there is no extension at all, they are giving me a penalty of debarment for 5 years. This is how disproportionate it is. But there are judgments of the Supreme Court where a 10-feet shed fell on people, where 1 person died and 11 person injured, and the Supreme Court said that 5 years is enough. And for not making payment for wages for the work I have not done, I am disputing that I have done the work.
The period that you worked ended on 26th of May
27th of May 24, which is the first extension which I accepted.
27th May 24 you accepted?
First extension I accepted. I worked up to the first extension. But I did not work in the second extension and the third extension. Yes. But since I have misquoted that date in my letter.
I understand the period that they have mentioned in page 56, 27th May 24, you worked till 31st August 24, you worked.
I have not. Only up to 27th of May 24, I have worked. I have paid wages up to that period. That is the extended period from March to May. That is the first extension.
To May, that is 26th of May is the last date you worked.
Yes.
From 27th onwards, you did not work.
So I have not paid.
All right.
And now, kindly see, when they say this, when I say that I don't want to work for you.
Yes.
And all this is coming in 2025. when the period has extended period, original period, everything is extended 2024. Kindly see the malice in the action.
All right.
Now, this is the first part.
Next.
Payment is not your point here. Now, my lord, the other part is, my lord, the implementation of this debarment in the GEM portal. Now, my lord, probably they will argue that this is guided by page 58.
Yes.
This is the government e-marketplace incident management policy. This deals with how a debarred person is to be dealt with in the GEM portal. But kindly in page 58 marks the date. Applicable with effect from 25th of November 24. All my chapter has ended before this. Now, kindly take the relevant clauses in the this one. Kindly take page 60. Bottom.
There must have been something which was in place when you worked, when your contract was in force. There must be some incident management policy. Not this one, 58 is applicable from November. But prior to November, there must be something.
My lord, for the my lord, that is not in my knowledge, my lord. That
There
is
has
not in
to
my
be something. It cannot be that it only started from November. Prior to that, there must be something.
My lord, perhaps they are proceeding on this basis. That is what we find from the.
Where from did you get?
My lord, if your
Did
lord,
they mention anything about this incident policy?
My lord, if your lordship kindly sees,
Yes.
page 90,
You're right.
which is the document as far as the second part of my challenge is concerned.
Yes.
Kindly takes the your lordship will find the heading incident responses. Thereafter, the second entry.
Yes.
GEM admin added a comment on 21st March 2025 addressed to Kolkata.
Yes.
The buyer has raised an incident mentioned under the reasons given in clause 2.2 Roman 3 of the incident management policy. Buyer is required to attach a copy of the debarment issued by the competent authority as per clause 2.2 Roman 3. Hence, the buyer is requested to upload the applicable document within 3 working days. Now, this clause, if we relate back to this document, 2.2 Roman 3, kindly, my lord, your lordship will find it, page 62. Middle.
Yes.
Implementation of GEM of buyer specific debarment suspension orders issued by respective buyer organization department so and so. In such cases, action will be taken on the GEM platform after the buyer concludes its internal debarment proceedings in compliance with the extant Department of Expenditure guidelines on debarment of sellers, service providers, and shares. A copy of such debarment order issued by the competent authority of the buyer organization or so and so. The buyer by so and so by state shall raise incident against the debarment form with a copy of the debarment order. Therefore, that requirement at page 90 relates back to this clause. Unless there is in a historical document, there is same 2.2 Roman 3.
All right.
Malad, even under this document, if we go by this document, though my point is that it is not applicable to me. Now, if your lordship kindly comes back to page 60, which I was placing.
Yes.
Kindly takes 1.7 last 2 lines.
Yes.
In case of implementation of debarment orders issued by buyer organization under single ministry, department, organization or state, the same shall be implemented, enabled, actuated by GEMS separately, independent of the actions taken by the GEMS incident management policy. This has not been done. Separate single ministry or department's action has not been applied upon me separately. Number 2, kindly takes page 62. Second last point B. Once the incident is escalated by the buyer,
The system will send show cause notice to the seller only for intimation of action being initiated for enabling actuating by a specific debarment on gem. In response, seller can only point out discrepancies about details entered by the user, raising incident and what is contained in debarment order. Merit of the debarment order shall not be discussed or examined in the process of implementation of the orders of gem. This has not been done. If this was done to me, I could have replied by saying that I have only been debarred by the so-and-so directorate. Therefore, kindly do not disable my entire account.
This entire thing is faceless, isn't it?
It's an interface. It's a software.
Right. So there is no face. So who do you go to in case there is a problem? This show cause notice to the seller was not given. Only for intimation on action being initiated for enabling. Specific debarment on gem. Seller can only point out the discrepancies.
Been debarred completely. Lordship will find that at page 90. If your logic kindly comes back to page 90. Under the incident responses, the first entry.
Yes, your account has
been debarred from 29th July 2025 to 20th February 2027 due to, as per debarment order dated 21st February 2025 of the buyer for the maximum permissible period of 2 years as per the Department of Expenditure. So my entire account has been debarred. Now, this is not the intent of the debarment notice. So, if I can summarize my points, as far as the debarment is concerned,
what is the Department of Expenditure guidelines of the
that is the
ministry?
Page 58 I placed.
58.
Starting from page 58, the clauses I placed at page 60 and 62.
No, page 58 is the gem, not the gem. The departments, they must be having Department of Expenditure of the Ministry of Ordinance.
Yes, perhaps this is the guidelines of the published by the Department of Expenditure to be followed by GEM. If your lordship kindly takes page 83, we have got our hands on one memo of the Department of Expenditure, page 83.
Yes.
Kindly take Roman 3 and Roman 4. Of point 1. A procuring entity may debar a bidder or any of the successors from participating in any procurement process undertaken by it for a period not exceeding 2 years. If it determines that the bidder has breached the code of integrity, the ministry department will maintain such list, which will also be displayed on their website. The bidder shall not be debarred unless the bidder has been given a reasonable opportunity to represent against such debarment. This is what we have got our hands on, as far as the Department of Expenditure is concerned. Guidelines too. Now, taking all these points, I had raised an incident with the GEM portal. The lordship will find that at page 57.
Yes.
Where all these points have already been taken. Additionally, one point has been taken in the second last paragraph. Your lordship will find. It is stated that the Honorable Guwahati High Court passed a judgment and order in WP so and so in the case of this petitioner versus Central Warehousing Corporation by setting aside the drastic action of the respondent on the ground of violation of natural justice is similar aspects. Now we decided to institute a case on the buyer and so and so and so. So these points we have taken before the GEM portal also. But today the situation is that I am not being able to participate in any tender. I am not through the GEM portal. Now, if I can summarize the point, first of all, the debarment on the face of it is bad because there.
No, I followed it. You give me that supplementary or something where you giving those two letters.
These two documents. Supplementary, I could not affirm.
All right,
but
let me see.
Their document.
Let me see. Let me see.
This is their show cause, and this is my reply, which is irrespective of my typing mistake. That original contention is mentioned that I have worked till so and so.
Hmm. See, page 2 of their communication, 17th of January, the last line mentions about delay refusing in payment of wages, salaries, as per contract is for debarment. This is not there, isn't it?
In the other document in the writ petition.
Yes.
Paragraph 5 is the quotation which is there in the subsequent letter, paragraph 5. By suitable action of debarment will not be initiated against you. Then paragraph 7 is also important. They say that this is a final warning. Procedure will be started after this. Then my reply, absolutely categorically pointed reply that in my eyes there is no contract after 27 May 24. But problem is that, Malad, in the debarment order, they don't deal with clause 2.1. They stand by their interpretation, Malad, which is absolutely on the face of it wrong. It cannot, by any stretch of imagination or interpretation, be taken to be the period of the contract.
Very well. Yes, please.
Two decision, Malad, I intended to cite, I think. To Calcutta there. Malad, this is 2014, volume 14, SCC 731. 14, volume 14, SCC 731. Kindly take paragraph 17. But this deals with the point of disproportionality also. 17, first.
Yes.
That apart, the power to blacklist a contractor, whether the contract be for supply of material or equipment or for the execution of any other work whatsoever, is in our opinion inherent in the party allotting the contract. There is no need for any such power being specifically conferred by statute or reserved by the contractor. By contractors. This is because blacklisting simply signifies a business decision by which the party affected by the breaches decided not to enter into any contractual relationship with the party committing the breach. Between two private parties, the right to take any such decision is absolute and untrammeled by the constraints whatsoever. The freedom to contract or not to contract is unqualified in the case of private parties, but any such decision is subject to judicial review when the same is taken by the state or any of the instrumentalities. This implies that any such decision will be open to scrutiny, not only on the touchstone of the principles of natural justice, but also on the doctrine of proportionality. A fair hearing to the party being blacklisted thus becomes an essential precondition for a proper exercise of the power and a valid order of blacklisting made pursuant thereto. The order itself being reasonable, fair and proportionate to the gravity of the offence is similarly examinable by a writ code. Then 20. It is also well settled that even though the right of the writ petitioner is in the nature of a contractual right, the manner, the method, and the motives behind the decision of the authority, whether or not to enter into a contract, is subject to judicial review on the touchstone of fairness, relevance, natural justice, non-discrimination, equality, and proportionality. All these considerations that go to determine whether the action is sustainable in law have been sanctified by judicial pronouncements of this court and are of seminal importance in a system that is committed to the rule of law. We do not consider it necessary to burden this judgment by the copious reference of the decision subjects of so and so. But here I'll stress on one word in the second line, motive behind the decision. Because when I said I will not work, they suddenly started playing this game of debarment with me. Then 25. Suffice it to say that debarment is recognized and often used as an effective method of disciplining deviant suppliers or contractors who may have committed acts of omission and commission or frauds, including misrepresentation, falsification of records, and other breaches of the regulations under which such contracts were allotted. What is notable is that the debarment is never permanent, and the period of debarment would invariably depend upon the nature of the offense committed by the erring contractor. Then 28.2. Next page. Secondly, because while determining the period for which the blacklisting should be effective, the respondent corporation may, for the sake of objectivity and transparency, formulate broad guidelines to be followed in such cases. Different periods of debarment depending upon the gravity of the offences, violations, and breaches may be prescribed by such guidelines. While it may not be possible to exhaustively enumerate all types of offences and acts of misdemeanor or violation of the contracted obligation by the contractor, the respondent corporation may do so as far as possible to reduce, if not totally eliminate, arbitrariness in the exercise of the power vested in and inspire confidence in the fairness of the order which the competent authority may pass against the defaulting contractor. And another one, 2021, Volume 2 SCC 551. 2021, Volume 2, SCC 551.
Yes.
Can you take paragraphs 13, 14, 19, 21, and 25? 13, 14, 19, 21, and 25.
25.
25. I'm starting with 13.
Yes.
13. Internal page 8. Bottom.
Yes.
At the outset, it must be noted that it is the first principle of civilized jurisprudence that a person against whom any action is sought to be taken or whose right or interest are being affected should be given a reasonable opportunity to defend himself. The basic principle of natural justice is that before adjudication starts, the authority concerned should give the affected party a notice of the case against him so that he can defend himself. Such notice should be adequate, and the grounds necessitating action and penalty or action proposed should be mentioned specifically and unambiguously. An order traveling beyond the bounds of the notice is impermissible and without jurisdiction to the extent. This court in Nazir Ahmed has held so and so, and it takes 14. Next paragraph. 13 last line, kindly take 13 last line in the next page. If these conditions are not satisfied, the person cannot be said to have been granted any reasonable opportunity of being heard. Specifically in the context of blacklisting of a person or an entity by the state or state corporation, the requirement of a valid, particularized, and unambiguous show cause notice is particularly crucial due to the severe consequences of blacklisting and stigmatization that accrues to the person or entity being blacklisted. Here it may be gainful to describe the concept of blacklisting and the graveness of the consequences occasioned by it. Blacklisting has an effect of so and so. These are fatal principles. Kindly take 19. In the light of the above decisions, it is clear that a prior show cause notice granting a reasonable opportunity of being heard is an essential element of all administrative decision making, and particularly so in decisions pertaining to blacklisting which entail grave consequences for the entity being blacklisted. In these cases, furnishing of a valid show cause is critical, and a failure to do so will be fatal to or any order of blacklisting pursuant thereto. Then 21. Thus, from the above discussion, a clear legal position emerges that for a show cause notice to constitute the valid basis of a blacklisting order, such notice must spell out clearly or its contents be such that it can be clearly inferred therefrom that there is intention on the part of the issuer of the notice to blacklist the noticee. Such a clear notice is essential for ensuring that the person against whom the penalty of blacklisting is intended to be imposed has an adequate, informed, and meaningful opportunity to show cause against the possible blacklisting. Then 25. The mere existence of a clause in the bid document which mentions blacklisting as a bar against eligibility cannot satisfy the mandatory requirement of a clear mention of the proposed action in the show cause notice. The corporation's notice is completely silent about blacklisting, and as such, it could not have led the appellant to infer that such an action could be taken by the corporation in pursuance to the notice. Had the corporation expressed its mind in the show cause notice to blacklist, the appellant could have filed a suitable reply for the same. Therefore, we are of the opinion that the show cause notice that so-and-so does not fulfill the requirements of the valid show cause number so-and-so. Therefore, my lord, the period also has to be mentioned. I could have replied that no, even if it is an offense, a breach of the contract, you cannot debar me for 5 years. It is absolutely disproportionate.
It's for 2 years, isn't it?
5 years.
5 years.
The Department of Ordnance has debarred me for 5 years. But JAM has debarred me only for 2 years because the memo of the Department of Expenditure which says that JAM will only debar for 2 years. Therefore, my lord, my primary prayer is, my lord, kindly stay the debarment notice so that I can work. My lord,
yes,
secondary, my lord, is that, my lord, JAM should allow me to work, but to participate in the tenders.
My lord, in my humble submission, no stay order should be granted.
Yes.
Since my lord, lordship come to page number 51 first. Here lordship will find that from 1st June 2024 to 31st July 2024, payment not cleared. Next, my lord, 1st August 2024.
1 minute. First June.
1st June 2024.
But that period he did not work.
My lord, this was the extended period.
Can you
cannot-
force upon extension? Tell
Yes,
me.
yes.
Under
As
which
per
provision?
option clause.
Show me, please.
2.1.
Please show.
Page 41. Lord.
Yes, please.
To buyer added bid specific terms and conditions. Generic 2.1. Option clause. The purchaser reserves the right to increase or decrease the quantity to be ordered up to 50% of bid quantity at the time of placement of contract. The purchaser also reserves the right to increase the order quantity by up to 50% of the contracted quantity during the currency of the contract at the contracted rate. Bidders are bound to accept the orders accordingly.
Please show me that it specifies time.
Pardon me?
Please show me.
But this is from the contract.
Contract relates to the quantity of the work that you will allow the contractor.
Right.
Where is the period of extension mentioned? That
Period
you
of
can go
extension-
on extending it according to your sweet will. Where is that?
No, Lord, second extension was made on 31st of May
Sir,
2024.
you chose to extend it unilaterally. The petitioner was not agreeable to work. Will you force somebody? Can you force?
But Lord, under the option clause, under the option clause, they're bound to.
Sir, the option clause relates to quantity and not the period of the contract. Show me there is any provision where you could have unilaterally extended the period of contract. Please show me.
Well, that is not there.
Then
That is
how
not
could
there.
you?
But thing is this,
No thing.
No.
The first
they
thing
have
first.
raised the allegation that no SOCOJ was given, Lord, as per page 83.
Whatever their allegation is, I'm not going to go into it. You first satisfy that you could have extended the contract unilaterally without taking their consent.
1 minute. Lord.
Yes, please.
Why my learned senior takes instructions? Can I point out page 40 where quantity has been defined? It may help my learned senior. Quantity has been defined in this document. Quantity means resources. Page 40, just above the heading annexure 1. There's a heading. Q is equal to quantity number of resources.
Quantity means
not time.
Lord, under JAM portal, Lord, the notification which was issued, then Lord, it will appear Amit Kumar Mondal buyer escalated.
Where are you reading from?
Lord, this is the
document you have it
yes,
with you.
document.
All
We
right.
have not yet filed any affidavit.
Yes, yes. What does it say?
It is written there. Firm was requested to make payment to their deployed employees worked for this office for the period from 27 May 2024 to 31st.
Dude, I am not going to go there.
I am coming to, my lord. I am coming to 3 line only. Let's say have the blood patience. Within 24th January 2025, which was not complied by the firm as on date, firm's clarification on option clause related to increase or decrease the quantity is also not acceptable. To this officer's extension of contract was made on man days / period basis with the concurrence of IFA and sanction of CFA.
Where
The
is this
quantity
concurrence?
being not meant-
Where is the concurrence? Show me the concurrence.
Delaying / refusing in payment of wages / salaries to the resources deployed to consignee location as per contract condition. This is there. By
Show
filing
me,
affidavit, all these documents we shall place.
show me
Yes.
that you extended the contract
Yes.
upon consent and you had the power to extend it without consent. Where is that document? That is the very question.
Okay.
The point that they are
I have
harping is
understood, Lordship.
you cannot force them to work. And for the
I have
period
understood, my lord. I have-
they have worked, they have paid on and from 27th May. They did not work, they did not pay. It is as simple as this. Could you have debarred? And if debarred, could it be for the entire period of 2 years, 5 years? These are the preliminary issues that have been raised. But prima facie, I am satisfied with the documents that are here that you could not have debarred them.
But practically, we have not placed any document up till now.
Yes,
Record.
true.
Yes.
Show me, because that is the contention they have raised in the writ petition, that you have to show at least that the extension was permissible. Show me that.
Well, okay, correct. Practically, my lord, we have been briefed only last evening.
No, all said and done. Please show me whether you have something.
Documents are there as per the
Yes.
instruction, my lord, given by the officers, those who are present before the court, but those are not readily available here.
All right. So what do you propose?
If your lordship really take it tomorrow or day after tomorrow or any day, my lord, we can place the document.
Day after tomorrow, we are not working.
Then the day
Right.
which will be which will suit to your lordships according to your lordships.
All
weakness.
right. When was this gem debarment take place?
This gem debarment 29th of July. I just give the
29th of July 2025 2:56. All right. How soon can you come up?
Pardon, my lord?
How soon can you come up with these documents?
My lord, by way of
Minimum documents.
by way of affidavit, my lord, not elaborate affidavit, but
Short affidavit.
we shall place it.
When?
On the next date of hearing, when
Yes.
lordships will see, they have been asking for 7 days.
7 days?
Yes.
Next Thursday, I'll keep it.
Next Thursday,
You provide advance copy to your learned friend?
obviously.
will kindly stay the department in the meantime so that I can participate in the
Oh, that will possibly create some problem. This is the reason I want to shorten the time. Let them show me something.
Yes.
Then, if they are unable to show on the first day, then I can
at least the
pass.
ad interim protection as far as the GEM portal is concerned, so that I can participate in the other works of DO, not
But
DO.
bank guarantee has not been forfeited up till now.
All right.
Bank has not taken any steps.
Hmm.
And my lord, so far
What
this
about-
debarment is concerned, this is 5 years as per the my lord
Why did you upload it? Why did you upload it in the GEM portal?
GEM portal, my lord, is the authority through whom, my lord, tenders are being processed.
Yeah, that I understand.
Yes.
But this was the problem was going on between you and the petitioner.
My lord,
And
GEM
the petitioner
portal
had raised issues.
is performing under the Ministry of Expenditure.
Yes.
And we are working, and the petitioners have been working, my lord, under the Ministry of Defense. My lord,
That is
yes,
immaterial.
if your lordship kindly comes to
That is the marketplace through which everybody gets the work.
Lordship, if your lordship kindly come to page 85,
yes,
it would be clarified. Guidelines on debarment of funds from bidding.
Yes.
The guidelines are classified under following two types. I. In cases where debarment is proposed to be limited to a single ministry, the appropriate orders can be issued by that ministry itself, thereby banning all its business dealing with the debarred firm.
Yes.
II. Where it is proposed to extend the debarment beyond the jurisdiction of the particular ministry, that is covering all central ministries / departments, the requisite orders shall be issued by the Department of Expenditure, Ministry of Finance. Therefore, my lord, GEM portal which is done, my lord, we are not ready to answer to that, as because they are under separate ministry. We are not representing them. We are representing only Ministry of Defense.
You have made them parties of them.
You are
I am
the Union of
only
India.
Respondent number 1 to 5.
Ministry of Defense, Ministry
And
of
Ordnance Factory, that is another Ministry of Defense.
All defense.
Yes.
Oh, Ministry of Expenditure.
And Ministry of Expenditure, GEM portal is under Ministry of Expenditure.
GEM portal is a different authority.
No, but under the Department of Expenditure, Union of India.
Department of
separate. They are not.
Department of Expenditure. Have you impleted?
No, GEM we have done 6.
GEM is separate.
Government
GEM is represented by a different council. No, but Department of Expenditure also you have not. The Ministry of Expenditure, Department of Expenditure, you have not implemented as party. Otherwise, he appears for the Union of India. He could have taken steps.
Own rules, Ministry of Defense.
Yes, that I understand.
And on the basis of that, my lord,
at least the debarment notice is by my learned senior friends client. My lord, if it is not reasonable, they have not the right to keep me out of my business even for one day. That is what the Supreme Court says, that if you are a private body, you do it. You have the right to contract.
That
but
I
if
understand.
if you are a state, you cannot do it without reasons. And just to avoid these reasons, your lordship will not find a mention of 2.1 anywhere. No decision on 2.1.
And thing is, GEM is the learned counsel who appears for GEM is not here today.
another notice should be issued upon the GEM by my learned friend.
Do you know who appears?
But I'll find out from other judgments.
Yes, I forgot his name.
The GEM notice.
No, the learned counsel appears on regular basis. I just missed his name. You please come back next week. Let me see. Ashwin, dekhiye. The petitioner is aggrieved by the debarment order that has been passed by the Ministry of Defense. Not Ministry, Directorate of Ordnance, and uploaded in the GEM portal, whereby the petitioner has been blocked from participating in any contracts. Stop. Next. The sheet anchor of the petitioner is that the petitioner performed work for the initial contractual period. Stop. Thereafter, 3 extensions were given by the employer. Stop. The petitioner, though accepted the first 2 extensions, but categorically refused to accept the 3rd extension. Stop. The petitioner objected to the extension being unilateral. Stop. According to the authority, as payment of wages were not made for the period which the petitioner did not accept extension of the contract, comma, the penalty of debarment has been issued. Stop. The petitioner submits that the debarment order is bad and could not have been passed in the facts and circumstances of the instant case. Stop. Paragraph. Learned advocate representing the respondent numbers 1 to 5 seeks time to file a report. Stop. Next. Hearing of the writ petition stands adjourned till 28th August 2025. A very short report indicating the power, not power, but the authority, the authority of the respondent to unilaterally extend the period of contract shall be placed by way of a report to be affirmed by a responsible officer of the respondent authorities. The report shall also disclose the guidelines relating to blacklisting and debarment. Stop. Advance copy of the affidavit shall be served upon the learned advocate representing the petitioner by 27th. In the event the respondents are unable to satisfy the court with regard to the unilateral extensions, comma, then the court will be compelled to pass interim order in favor of the petitioner. Let the judgments and everything remain, and would you like to file a supplementary? It's better you do it.
I'll do for you.
Answer. A leave granted to the petitioner to file supplementary affidavit annexing documents which inadvertently were missed out in the writ petition. Affidavit of service is taken to the court.
My lord,
Yes.
may I seek an indulgence? My lord? May I seek an indulgence, my lord? My item number is 24, which is
Where is it appearing? Urgent motion? All right, urgent motion. Yes.
my lord. My item number is 24 in the today's list, my lord. The SBI life insurance matter, my lord,
Yes.
wherein my lord has directed the petitioner to serve a copy of the writ petition to the liquidator as well. So, my lord, for an extreme emergency, I have to leave court, my lord. May I file the affidavit of service?
No. The matter will not be taken up today.
Will not?
No application. My lord, may I indicate
Applications will be taken up.
one thing, my lord? My
Tomorrow, since
tomorrow, kalke ki newa hobe?
Tomorrow, since I'm leaving for
Urgent motion thakbe? Yes.
tomorrow, since I'm leaving for Delhi to visit my daughter, I have
Somebody, I can adjourn it. No issues.
my lord,
much obliged.
my junior had mentioned this matter previously. This is item number 515. Then application, my lord. Your lordship had asked us to mention it when application is being taken up. My lord, item number 515. I have already got in touch with the other side. No, not today, my lord. Previously, my lord.
Previously mentioning the day gone, mentioning gone.
My lord, 515. My lord, I've already
carried over.
But I had intimated the other sides also.
Your intimation will not do. Today it will not be possible.
My lord, I am appealing for the petition.
I've taken instructions, my
My lord, I have also taken instructions.
The settlement has gone because they failed. So now the company insists for payment of the foreclosure amount, that is 9,26,000, my lord. 5 lakh by tomorrow, and the remainder 4,26,000 within a week, my lord.
Within a week?
My lord, I pray for only 10 days. I'll pay off that foreclosure amount also.
7 days. The court is not here to bargain. This is what the bank says. 5 lakh by tomorrow. This is what it has been submitted. Please come. 8 number.
And this stays the, my lord, order of possession then.
Handing over the foreclosure statement so that they can.
Okay. The property of the petitioner, which stood mortgaged to the bank.
My lord, not the bank. It is a.
Oh, it's the non-banking financial corporation, NBFC.
This is the.
Is to be taken possession of by obtaining order under section 14 of the SARFAESI Act. Stop. The petitioner prays for a direction upon the financial institution to permit the petitioner to foreclose the account by making payment. Stop. The total amount that is due to the bank is rupees 9.26 lakh. According to the bank, if the petitioner pays a sum of rupees 5 lakh by tomorrow, date 22nd August 2025, and the balance by 30th August 2025, then the bank may foreclose the account of the petitioner, loan account of the petitioner. Bank hobe na, ekhane financial institution. Acha, next. It will be open for the petitioner to act in terms of the aforesaid direction, which has been forwarded by the representative of the bank and is being submitted by the learned advocate representing the bank. Amar bank, সবগুলো financial institution. ঠিক আছে? Hearing is adjourned till 1st of September.
Can you change the repossession notice till that is
The financial institution
Till 1st
is
of September.
directed not to proceed with the taking over of physical possession of the secured asset till the 2nd of September 2025. Put this up as to be mentioned.
Grateful, madam. Grateful.
Item number 10 take to down to.
My application, my lord.
Yes.
May I file my affidavit of service? Challenge in this writ petition is to.
Who is your other side?
My learned friend is appearing for the bank.
Are you for the state?
Bank.
Answering respondent is the bank?
Yes, the state is, DM has passed the order, state is enforced.
Section
The bank
14?
is, yes, 14 order.
All right, yes.
2 memos, March 2023, November 2024, issued by the district magistrate under under section 14(1). No communication to me. January 20.
Who are you?
I am the borrower.
All right.
January, it's a borrower, it's a residential property, I reside there.
All right.
January 2025, a sale notice is issued by the bank. I challenge it by way of a section 17. 16th July, the bank comes to affix on my premises a intimation saying that possession will be taken today.
July
2025. Possession will be taken today, pursuant to memo issued by district magistrate in 2023.
All right.
I go to the DRT and seek a stay of the bank's intimation that it is going to enforce that order there. I file that application on 29th of July. The DRT says I will hear you on 18th of August. On 18th of August, he takes on record a 9-point affidavit filed by the bank before the DM, no copy supplied to us, and says everything is all right. The short point which he notes in the order, and I am not challenging the DRT's order, I am only challenging the memo of the district magistrate. My short point is that there was no service of the section 13(2) notice. Your lordship knows, and I'll show your lordship, it's admitted that the notice that they had allegedly sent returned undelivered. So they proceeded under the proviso of Rule 3 of the enforcement rules and made paper publication. The requirement is you have to make paper publication and affixation. They only say that they make paper publication. I have not been able to find it on their website. They may have forgotten.
Show me the order of the DM.
The order of the DM is not with us. We have never, it's not seen the light of the day.
23, you said it was
Yes,
passed?
it's not, we have not received it. The DRT, yes, their submission before the DRT was the order of the DM shows copy to me.
Where is that? The date at least?
The date your lordship will kindly take page 515, volume 4. Your Lordship is.
Yes. Intimation regarding physical possession.
Yes,
15th of
16 July.
2024.
Third paragraph.
Yes.
With reference to the above, we have to inform you that the bank has received a communication from so-and-so after fixing a date on 21st August at 11 hours for taking possession of the secured assets stands in the name of Bijan Kumar Sarkar, Subroto Rai and Kakuli Rai in compliance to the order under section 14 of the Sarfaisi Act issued by the learned district magistrate, South 24 Parganas, vide memo number so-and-so dated 22/2023 and vide memo number so-and-so dated 28th November 2024. These memos never served on me. I don't know the contents. And I'll show your Lordship 13.2 service or the issue regarding that. Kindly, my lord, take page 431, which is in volume 4. This is a reply by a bank to my representation, my correspondence. It's not a representation, it's a correspondence.
Yes.
Kindly, it's 3rd August 2022. Kindly come to page 433. Your Lordship will see there is a table 5. Then suddenly on so-and-so, a posse of men descended to my property and created ruckus and served surface and threatened us. Not knowing what to do as hapless borrower, we somehow managed to pay so-and-so. The bank's comment is on the right. This is wrongly stated that suddenly on so-and-so, a posse of men descended onto my property and created ruckus and served 13.4. Recovery proceeding was initiated as per Surface Act and demand notice under 13.2 was served upon the customer through India Post, which was returned undelivered. Thereupon, notices published in 2 newspapers on 9th March 2022. Now, my lord, kindly just take rule 3 of the security.
Did you not know about the symbolic possession being taken on the 8th of June 2022?
Symbolic possession, I knew. Those are all under challenge in the DRT.
All right.
Now, my lord, kindly see, and that is the ground. Non-service of 13.2. Now, kindly, my lord, take the security interest enforcement rules.
How much is the due?
101 installments due till date, we have paid 86. The last 5 installments we have tried to pay, it's bounced back because they blocked the loan account. Till February 2025, my client has paid EMIs. There is a discrepancy during the period of COVID. There is a RBI circular. They were mandated that they could have given me a restructuring proposal at that stage. Nothing done. It's a residential property. But I don't think that if the loan is restructured, my client will not pay it. But kindly have a look at rule 3. Dada.
It's all right. DM's order.
May I indicate only 2 things?
Let me understand what he has said.
Yes.
Clarify the query of the court first. 23 order.
22 order by the memo in 23. Order is 22. Memo
DM's order is 22. You are executing here in 25 August?
It is up to DM only. We are not executing. The Mallet knows all these procedures. Section 14 order, 90% of the order is not passed by the DM without indulgence of my lord even. They are not passing any order without we file a writ petition saying
I get it.
Yes.
But then, if the DM has passed an order, there is a period mentioned within which that order is executed.
This is my lord's order only. That section 14 order cannot become functions officio if it is put beyond 60 days. My lord's order only.
Sir, the query is the DM when passes order, there is a period mentioned that it has to be executed within certain period of time. If the order is passed in 22, how are you executing in 25?
He has extended that. He has given me order to that.
Right. So you have extensions?
Yes, yes.
When was the last extension given?
That I do not have right. I will come back.
Because the dates that have been read out, I see the last one is of November 2024. We are in August.
Yes.
It is usually for a period of 6 months.
Yes.
So that period has also expired. Where is the current order?
There cannot be execution even.
Are you doing it with a valid order or not? This is what
I know it is a valid order. My lord's order. I am equipped with my lord's order, which says that DM can extend his order beyond the time also. So he extended that.
Is it extended?
Yes. That is why there is execution.
So you say that it is extended.
Yes.
Where notice is given to the petitioner?
Can you see that? Yes, yes. It is not by me. It is by DM office only.
DM office served notice?
Yes, yes.
You have copies to show that the petitioner was served about the section
Served,
14?
I cannot know because the DM office has been given a notice. It has come back to the DM office only, acknowledgements and all.
But
And
then a
before that-
hearing is given.
Hmm.
You are the bank.
Yes.
A hearing is given.
Yes,
The
he
DM
said
is not the adjudicating authority.
Yes, yes.
But then formally, certain points are to be noted by the DM as to whether they have been complied. The
Yes, yes.
compliances. You have all those.
Yes.
Everything is there. All right. Now you say what you've got to say.
My lord knows what I am going to say. Say is that these all pleadings, whatever prayer they have made in this petition, the same prayer, same pleading that there is section 17 application is filed before DRT.
Yes.
So the DRT has passed an order on section 14 application. They have filed an IA also. The DRT tribunal has passed an order. Good, bad, indifferent, maybe good, maybe wrong. So there is the section 18. My lord, kindly see section 18 once of
Yes,
the
yes,
Secrecy
yes.
Act, which
Yes.
says that he can go travel to the DRT, challenge this
Yes,
order
yes.
passed by DRT.
His
So
submission
as
is that
far as the-
section 14. He is not challenging the submission. Specifically submitted is that he is not challenging the order of the Debts Recovery Tribunal.
Right.
What is challenge
He has not
is
served
this
the 13.
section 14. 13.2 will be taken care of by the tribunal. Section 14 was not served. He is not aware of the order passed under section 14.
May I have answer to that?
Yes, please.
Firstly, there is no requirement to serve an order of section 14 to the borrower. Even if that is there, it has been served upon. I have a copy of that.
Show that it has been served upon the
Served
petitioner.
with my lord knows it has served by
Then-
DO option.
Dispatch.
It is served by the DO, not by bank. It is served
No,
by
no, I understand the DM, whether it was,
Yes.
did the bank make the petitioner aware of this section 14 order?
Not
No, no.
16 July.
No,
Never.
16
no,
July.
never. It is by the DM only who has served them.
How much money does he owe?
2 lakh around.
60.
Yes.
No, no, that
60.
is that is with penal interest.
My lord, if he goes into the merits of the matter, my lord knows.
No, no, the court is not going into the merits
No,
of
no,
the
he-
matter.
my lord understood.
The preliminary things the court wanted to
My lord knows.
make sure
I know.
as to whether
My lord also knows what my answer will be.
as to whether the procedures were taken care of. Right. Section 14. Who is appearing for the state? Did you serve?
DM office has been served.
A DM office, nobody will appear. You have to serve the GP's office. Till you serve the GP's office, nobody is engaged to act on behalf of the DM. Never. In the absence of the learned advocate for the state, it becomes difficult.
Possession today keeps it tomorrow or Monday. If the DM office can show that they have dispatched the notice to me at my address, I am out.
What is to be done?
My lord knows my answer. I leave it to my lord. The only is that let us see the color of the money. 60 lakh is due.
Yes.
And my lord knows how difficult to get an order of DM.
What is the principal amount due?
53 lakh and not.
53. And 7 is the
Interest and all.
interest.
Till now.
How much is the due?
And 101 installments have fallen due as of today, out
No,
of which
give me
86
the
have been paid.
figure.
So 15 installments on that side would be 70,000. 15 would be about 10.5 lakhs, and another 120, 19. So that's 34 installments into 7. It should not be 50 lakhs. The principal amount would for 34 installments should be about 21, 22 lakhs.
I do not know. You know the figures.
34 installments of 76,000 and odd each would be due on the loan, and out of that 19 are still not due, 15 are due as of today.
Get the figures.
I have the figure.
You have the figures. Principal amount is 50.
It is not in hard copy, my mobile.
Yes, yes, soft copy. How much is the figure? Check up. Is it 50? Just to show your bona fide, how much can you pay?
I have been going on paying the EMI regularly up to February 2025. March, April paid, money has bounced back because they've blocked that loan account. May I say this, my lord? From March to August,
You let him pay something, you give the figure as to what could be paid so that he can pay it by tomorrow.
Around 60 lakhs.
60? No, one day you cannot expect.
No, I'm
60
not
cannot be.
50% even.
How much? 30?
Only one difficulty here. May I indicate?
Yes.
I take 2 minutes of time. I don't know how difficult to get the DM order. Then the police cost. Then that authorized officer DM gives a date. Now this date goes, no date will come after 6 months.
Sir, what will you do by taking
I will
possession?
not take. I will not be indicating that order also. If they will not pay, the DM is directed to hand over the physical.
No, that is all right. You tell me the figures
But I
first
said
so that
at
he
least
can also take instruction.
Of course, I say that 50% of that, at least 50%.
How much? 50% of what?
60.
No, he doesn't accept 60. The principal amount.
I leave it to my lord.
Oh, the court is not taking the money as if the court is
I
taking
say
the
that
money.
it is up to them.
No, it's your money.
Let them say.
may I say this?
How much can you
May I say
pay?
this?
By tomorrow.
I have asked my, but you
If you can pay something by tomorrow, then at least for the interregnum, stay, and thereafter the matter is there before the tribunal. When is the next date you said?
tribunal next date. Sometime in December, my lord.
No, the interim application you said will be taken up.
No, interim application has been decided.
Oh, it's decided?
The essay is there in December.
Essay is there.
That is 3/11.
3rd of November.
My lord, I'll say this. Let me put in 3 lakhs by tomorrow, and let me go on. There are.
Sir,
kindly hear me out.
Please do not bargain. The court is not here for that. It is only to give you some interim protection that the court is giving you this much of opportunity. Now the bank says 30 and you said 3. Sorry, sir.
I said 3 tomorrow, my lord, and then something more within the course of the month, my lord. I did not say nothing.
I don't think the bank is going to agree. The bank will agree to it, and the court is not going to force anything upon the bank. If the bank says yes,
and I go on paying the EMIs, my lord.
That is all right. But then
I tell you, lordship, my lord, if I take the figure at,
if you can give at least a reasonable figure which the bank will accept, then
You are the best person. I leave it to him even. As fast as he filed the writ petition, my lord, he can go to the DIT also. He can mention there also. He could have mentioned.
No, the DRAT he went, DRAT,
Yeah,
or the appellate forum. He's not challenging the order of DRT.
Section 14 order, my lord.
It's only the section 14 that he says.
And my lord has already decided section 14 in various modes. What DM can do, when not.
You take instruction. Yes, you take.
I come back at 2.
It's 2 already.
Sorry.
বলুন কি বলছেন?
আমি বলতেছিলাম
Yeah. What else? Did you take instruction? Yes. Where is the other side? He was just here.
He's just outside.
Right. Call the supplementary list.
Not sure, basically appear on behalf of the contempt of 1 UDMA.
Next. Has the order been complied?
My lord, service has been both the service complied. I'm led by Mayank Roy from the.
Has the order been complied?
Municipality is the answering respondent in this, where the.
You are not there for the municipality?
No, for the UDMA, Principal Secretary UDMA. Contempt of 1.
Who appears on behalf of the Mekliganj municipality? Then there was a direction for service
Right.
upon notice.
Well, that has been complied with.
Who did you serve?
Well, the advocate, my lord, who had appeared on behalf of Mekliganj municipality in the writ petition. Yes,
Please
my lord.
tell him to join online. Give a phone call to him. Make a phone call. Tell him to join. Has the order been complied or what?
No, my lord, the order has not been complied with.
Order has not been complied. What was to be done? Are you aware? What was the direction in the court? Court's order, are you aware of the court's direction?
My lord.
The direction was that, my lord, to consider the representation made by the petitioner, my lord.
Yes.
For compassionate appointment, my lord, the order says that for grant of compassionate appointment, there was
The
an
order
application.
page. Which page do I get that?
My lord, page 26 of my contempt application. Page 26.
To annex the entire writ petition. Yes. Did you intimate Mr. Bhattacharya?
My lord, I tried calling him, my lord, but he is not available, my lord. Not picking up the phone.
There is one more matter in the list. In case you can get him prior to that, then it is all right. Otherwise, the matter will be urgent. Yes, call
My lord,
Your Lordship, I appear on behalf of the contemptor, Your Lordship. Your Lordship, as per the directions of Your Lordship, we had made representation. The contemptor had made representations to the Directorate of Pension, Provident Fund and Group Insurance. Your Lordship, the pension has been revised and sent to the Treasury Office for disbursement. Your Lordship, this is
Complied? Learned advocate for the petitioner submits that the order passed by the court has been complied with. Step next. In view of such submission, contempt application stands disposed of. Pass over for the. Did you get Mr. Bhattacharya?
not, my lord, I tried contacting him, but he is not available, my lord.
Please
over
tell
phone.
him to remain present next Thursday. I am adjourning it for the day. At the line lignin, affidavit of service filed in court is taken on record. Mr. Kunaljit Bhattacharya, learned advocate, who usually represents the Mekliganj municipality and who has been served notice of the contempt application, shall make necessary submission on the adjourned date. Yes.
One.
Punar appearance to record. Next Thursday. Next Thursday. Yes, 10. Bank. What do you say?
What I have been able to convince my learned friend is 25 lakhs by 10th of September and my lord, we'll work out the balance with the bank.
Pass an order, my lord.
In default, my lord, you'll have to
Yeah.
make a default order.
That order indicate that in default, district
দেখি 10 নম্বরটা দেখি item 10 please come. Affidavit of service is taken on record. None represents the district magistrate despite service. Stuff. The petitioner challenges the order passed by the district magistrate under section 14 of the SARFAESI Act. Stuff. Specific submission is that the order was passed behind the back of the petitioners. Stuff. The order was also not communicated to the petitioners. Stuff. The bank has fixed date for taking over physical possession of the secured asset today. Stuff. The secured asset is the residential property of the petitioners, and the petitioners agree to pay certain amount for obtaining an interim stay of the order for taking over physical possession. Stuff. Paragraph. A securitization application filed by the petitioner is pending consideration before the debts recovery tribunal. Stuff. Learned advocate for the bank opposes the prayer of the petitioners. Stuff. It has been submitted that the bank took steps strictly in accordance with the provisions of the SARFAESI Act. Stuff. It has been submitted that huge sum is due and payable from the petitioners. Stuff. Paragraph. As the district magistrate is not represented, comma, the court is not in a position to decide the issue conclusively. Stuff. The securitization application is already pending consideration before the debts recovery tribunal. Stuff. As the petitioners, comma, to show their bona fide, comma, intends to deposit certain amount to the bank, comma, accordingly, the bank is directed to accept the amount without prejudice to the rights and contentions, without prejudice to its rights and contentions. That's it. The petitioners are agreeable to pay a sum of rupees 30 lakh to the bank by 10th September 2025. Stop. The balance payment shall be worked out by the parties. Now, balance again, the manner in which the balance payment will be made shall be worked out by and between the parties. Stop. Next. The bank is directed not to proceed to obtain physical possession of the secured asset till 12th September 2025. Stop. In the event 30 lakh rupees is not paid by 10th September 2025, comma, it will be open for the bank to proceed with the matter in accordance with law. Stop. The writ petition stands disposed of.
Only one thing I mean, district magistrate may be directed to provide physical possession after 10th September, if not default clause. District magistrate has to be directed.
No, but then since I have not seen the DM's order, because that is not here.
Difficult to take a date from DM. That is the only.
I understand. I have given you liberty to proceed. That I have given you. So you can get the order from the DM. Had that order been annexed, then I could have applied my mind. I have not seen the DM's order also. This was the difficulty. Next.
I'm grateful.
Call the applications. Personal appearance.
Personal.
Yes.
On behalf of the contempt lord.
Has the order been complied?
My instruction is the water connection has been affected by the Pradhan.
By the?
Pradhan. Who is the
Pradhan.
contractor?
All right, who's present?
I happy. He is happy.
Who is he?
He's a Pradhan. Pradhan is the contempt, my lords.
Yes. And why has there been delay in complying the court's order?
Because there is a problem, the local disturbance. One of the local residents claimed that the property, the common passage is her own property.
If you know there is a problem, then you should have acted accordingly. The notice was served upon the Pradhan, he did not appear. And that is the reason the rule had to be issued.
Yes, Lord.
And yesterday, the connection has been.
Only because today is the personal appearance. Please come. Give the name of that person. Shubhajit Karmakar.
Shubhajit.
Mr. Shubhajit Karmakar, the Pradhan. দেখে নেবেন নামটা। Gram Panchayat is personally present in court in answer to the rule. Stop. Learned advocate for the petitioner submits that yesterday the water connection has been given to the petitioner. Stop. Paragraph. Learned advocate for the contemptor submits that the order of the court has been complied with. Stop. Next. In view of such submission, the contempt application stands disposed of. Contempt rule stands discharged. Next.
569.
Has Vakalatnama been filed?
I undertake to file during the course of the day.
Why entire morning you were here? Why didn't you file the Vakalatnama? And he was present since 10:30 in the morning, I saw.
It has been executed, Lord. During the course of the day, we'll file.
Leave to file Vakalatnama. Leave to file Vakalatnama in the course of the day. Please do it. Yes.
I am for the petition, my lord. On 17th, on last.
I will seek in one indulgence. Last occasion, I am the contemptor, my lord, for one of 7 alleged contemptor. You will also directed to file affidavit. My lord, I inform me, I appeared, my lord. The contemptor is ill, my lord. He was ill. He could not made the affidavit ready. One and another indulgence to file the affidavit.
My lord, kindly see the order, my lord, passed on 17th July 2025, my lord. There was a direction also upon the Howrah Municipal Corporation.
Yes, so far as my case is concerned, as far as the Howrah Municipal Corporation case is concerned, the file has gone to Bali because it's a Lilua case. But already we have sought for that file, and file has already reached. Only some time may be given, I will come file with the report. The steps taken.
Will the corporation be the proper party to take decision?
My lord, may not be, because he is the main contemptor. But still, as your lordship passes an order, I have to take some steps.
My lord, on earlier occasion, your lordship directed to serve a copy upon the Howrah Municipal Corporation. Then, my lord, he appeared.
No, that is because possibly you
He also the party, my lord. He also party in the writ.
Yes, the writ was of the year 2018.
Contempt, he was not a part.
They also filed the affidavit in opposition. We have also filed the reply.
The writ petition is of 2018 when this bifurcation was not there.
But still, the contempt, I was not made a party. But my lord directed me to come with a report.
That is because I saw the Howrah Municipal Corporation was there.
For that reason, I am coming with a copy.
But then if the Howrah Municipal Corporation is not the appropriate authority, then...
No, Howrah Municipal Corporation is the appropriate authority, my lord.
Now also?
Yes, my lord.
It says it has gone to Bali?
They are under the Howrah Municipal Corporation. No.
Arey Baba,
they appeared file of Howrah Municipal Committee also filed the affidavit in opposition. They also heard me.
Well, in any manner, the file went to Bali, but I will come.
Does it fall as on date? Does it fall within the jurisdiction of the Howrah Municipal Corporation, or where is this property?
Lilua.
It must be within the Bali jurisdiction.
Lilua PS. In any manner, I have to take instruction, madam. Only some time maybe.
Well, I have to see that, madam. At that time, maybe
at that time it was Howrah. Now it has got to Bali, so it has to be Bali Municipal Corporation.
But still, I have to take instruction.
No. How will you take instruction if it falls within the Bali jurisdiction? You'll go and
I have to ascertain that, madam. I have to ascertain that.
Instruction.
As far as my knowledge goes, since I am also from Howrah, this should be Howrah Municipal Corporation, this property.
This will be Howrah Municipal
Benares Road,
Corporation.
the left side of the Benares Road falls to within the Howrah Municipal Corporation. The
All
right
right.
side
So,
maybe,
this is within the Howrah Municipal Corporation. Then it is all right. Please come. Learned advocate representing the
Any day after 4th September.
contemner number.
In this, I am not the contemptor.
Right. ও তো contemner ই নয়. The
আমাদেরকে contemptor করেছেন?
I don't see that you are the contemptor. It is only the private respondent.
Only the private respondent is the contemptor. In any manner, my lord have directed me, I will come.
that I will advance my argument why she wants to not.
What was the order that was to be complied?
What was your past
Interim order was passed not to create any third party interest. The allegation is in the meantime I have transferred to sub-room.
And is the writ petition disposed of?
No,
no, pending.
Writ petition is pending. Why don't you take it up with the court and finish it off?
That one I will do. My lord,
Filing this application, she wanted to make a score against the promoter.
I have
That
already
will
ordered
make
taken steps, wrote a letter for assignment, my lord.
Assignment?
Yes.
Why? Group 5 bench is there. You can go and get the matter heard.
That I am taking steps, my lord. Kindly say, my lord, page 18, my lord. The
But this is against an interim order.
Any third party interest.
Third party interest has been created by the
They have
promoter.
created.
The
And
petitioner
as the third party interest is created by the
complains
promoter,
violation
promoter is the
of an
sole authority
interim
to
order
reply.
passed by the court. Stop. The writ petition is pending final disposal. Stop. The learned advocate representing the contemptor seeks extension of time for filing affidavit in the contempt application. Stop. Paragraph. The contempt application was filed in April 2021 and considerable time has elapsed in the meantime. Stop. This bench is of the opinion that the petitioner ought to take up the matter for final disposal before the bench having determination. Stop. The
এটা হাওড়া দেখেছো বালি পাঠিয়ে দিতে যা পারে এগুলো না
The contempt can be disposed of. What will happen by keeping the contempt pending?
My lord,
The
they have
contempt-
violated the order, my lord.
Yes, yes.
The order, my lord.
Contempt has happened.
My lord,
Contempt has been
page
happened.
18, my lord. They have created the third party interest by violating the order passed by the Honorable Justice Chatterjee, my lord.
The contempt application stands disposed of. Stop. The court makes it clear that the court has not gone into the merits of the contempt application. Stop. It will be open for the petitioner to raise all issues before the court taking up hearing of the writ petition.
Including the amount of points raised in the contempt application, my lord.
What including the points?
They have violated
If
this
there
order.
is if the unauthorized construction is detected, the unauthorized construction will be taken care of. What remains? Everything will go. If the
But, my
demolition
lord,
is
during
there.
the pendency of this writ petition, they have passed this order, my lord.
Which order?
This order, my lord, not to create any third party interest.
That the court passed order. The court passed order.
Court has passed order, but they have
Yes.
created a first party, a third party interest.
I have followed
This is their allegation.
You go before the forum, the writ court, and get it settled. Call 216.
The petition disposed of.
Contempt disposed.
Petition disposed.
I am for the petition.
Yes.
Lordship order was, my lord, GPF conversion area tension during pendency of the contempt application area already been given. My but interest fund not been released. Last occasion, Lordship direct the, my lord, DI personally appear, and DI already all papers already been sent to the concerned treasury officer. Lordship treasury officer not been released.
Treasury officer
not been released the interest amount. Lordship kindly liberty, my lord, I will file, my lord, leave. We may be granted to treasury officer, I will party contemptor, and therefore
I want to hear what is the submission. Well, let him. You make submission. Why has interest not been paid?
Because whatever right he has,
Yes.
accordingly the entire amount has been paid. That is the pensionary benefit has been given.
Yes.
He doesn't have the right to issuance of the interest part.
Yes.
That is treasury officer or DPPG. In the writ application, DPPG was the party. DPPG also to be make a party will have to do that.
Main order was DI, Lordship directed the DI. Lordship, that's why I.
Where is the order of the court?
But DI doesn't have any.
Kindly see the Malad annexer TU1, page 19.
The DI was directed to recalculate the terminal dues and ensure payment within a period of 12 weeks from the date of communication. This was in 2024. And then thereafter, the aforesaid amount shall be paid to the petitioner along with interest. This is the direction.
According to Lordship's order, my lord, he has, so far his right, he has executed.
No, nothing doing. The court directed him to make calculation of the interest part. Did he forward it to the authority?
But, my lord, then he contacted the DPPG. DPPG should have been done. He has not done. Then
do not show me who is to do it. There is a direction upon the DI, and the DI is required to follow it up. Otherwise, I am going to stop his salary.
No, my lord.
No, and yes, I am not going to.
Submitting, my lord. Let the treasury officer be added as a party. Pass an order, my lord. They will.
The DI will follow it up with the treasury officer. The DI is not going to do it.
He already followed it up.
Yes,
please. Yes.
This is my submission.
Yes,
yes, whatever the submission is.
Malad, 2 minutes, Malad.
Kina?
Yes.
What is his name? Chandrasekhar? What is his name?
Chandrasekhar Julia.
Chandrasekhar Jaulia.
Jaulia. The district inspector of schools, primary education, Purva Mendipur, is personally present in court.
Appeal was being heard out.
Stop next.
Justice Tandon, my lord.
The court directed the district inspector of schools to recalculate the terminal dues.
My lord, let him. It will be easier, my lord.
Stop.
Deal with the matter, my lord.
Dues was to be paid along with interest. Stop. Though the principal amount has been paid, the interest part still remains payable. Stop. Paragraph. The district inspector of schools is directed to follow up the matter with the concerned officer and ensure that the interest is released in favor of the petitioner. Stop. The matter is made returnable on 25th September 2025. Personal appearance of the district inspector of schools is dispensed with for the time being. Call the next matter.
117. My lord, one more thing, my lord.
Yes, 217.
Lordship, I am appearing on behalf of the Boidopati Municipality, Lordship.
Yes.
Lordship, last occasion, your Lordship directed to follow up the matter, Lordship.
Yes.
This is our report. We have follow up with the DLP on 29th of September, Lordship. We have wrote a letter to the DLP, Lordship, and thereafter on 13th of August, Lordship, we have made a detailed letter to the Assistant Director, DPPG, Lordship. Lordship, what happened, Lordship? In this case, DLB refused to issue the PPO, Lordship, as now they are taken a plea that this petitioner was not a employee in the sanction post, Lordship. For that, Lordship, we have made a detailed letter, Lordship, on 13th August 2025, where we have mentioned that if your Lordship kindly come to letter dated 13th August, Lordship. And also we have requested them to consider the order passed in case of Shapun Dash, Lordship. Lordship, Shapun Chatterjee, Lordship.
Please come.
Lordship, my humble submission.
Leave is granted to the learned advocate on record of the petitioner to implead the Director of Local Bodies.
Milord, DLB, Milord, at this stage, Milord, DLB has no function. Lordship, can you see
the ex officio Joint Secretary, Government of West Bengal, Department of Municipal Affairs, respondent number 4, and the Director of Pension, Provident Fund and Group Insurance. Respondent number 5 in the writ petition as party contemners in the instant contempt application. Stop. The notice of the contempt the contempt application shall be served upon the aforesaid added parties along with all documents relating to the contempt. Stop. The matter is made returnable on 6th November 2025. Stop. Affidavit of compliance shall be filed by the contemners on the adjourned date. Stop. The chairman, Bodhubati Municipality, is personally present in court. Stop. He is directed to follow up the matter with the added contemners. Stop. The chairman is directed to remain personally present in court on 6th November 2025. I'm there. Next.
I'm about the petition. In this matter, the municipality fixed the date of hearing on 30th of my lord August. Due to the rainy season, my lord, this could not be demarcation cannot be completed, my lord.
All right.
And 30th of August, my lord, date was fixed for.
Please come. Learned advocate for the petitioner submits that the municipality has fixed the date for demarcation.
For inspection.
For inspection on 30th August 2025. Stuff next. Prayer has been made to post the matter after the said date. Stuff. In view of such submission, release the matter on 13th of November 2025. Did you serve?
Yes,
nobody has appeared.
They appeared, my lord.
They appeared?
They appeared.
No one is there today.
They appeared earlier.
All right. Let this order be communicated to the learned advocate representing the contemner.
290. Lordship, I am for the petition.
Milord, partial compliance has been done previously, Milord, due to the pendency of few litigations, Milord, and Milord stay. We could not, Milord, comply with your Lordship's order. Now, Milord, in view of the Milord, the end of the litigations, Milord, now we have taken a step, Milord, to comply on 18th of August, Milord. It is a G+3 building, Milord. The ground floor, we have demolished the walls and the entire thing. Photographs are annexed. And the top floor, Milord, there was a flat that was only vacant.
Whatever, when will you comply?
Milord, we require some more time. Moreover, Milord, the assistance of the police in order to vacate the occupied portion, that is much more required, Milord.
Your Lordship.
Yes, please.
Your Lordship, they have just sliced a portion. Your Lordship, I have the photographs. Your Lordship,
But I have also annexed.
It has already been repaired by the residents.
The portion which was demolished has been repaired.
Has been repaired, Your Lordship. In the evening only, this photograph was taken where the laborers
You go and demolish in the morning and the evening they go and
But
repair
I have the photographs. Kindly, Milord, peruse the photographs.
No, thereafter it has been repaired.
They are repairing.
Milord, I do not find any laborers or machinery work is being conducted. However, Milord, I shall take instruction, Milord.
Please come. Learned advocate representing Vidhannagar Municipal Corporation seeks extension of time for compliance of the order passed by the court.
Milord, the report, Milord, is...
Stop. The report of the engineers of the Vidhannagar Municipal Corporation signed on 20th August 2025 be written with the records. Stop. In view of the aforesaid submission, hearing of the contempt application stands adjourned till 20th November 20.
Only one indulgence, Milord, direction upon the police, Milord, to vacate the...
Commissioner of Police, Vidhannagar Police Commissionerate, is directed to render all necessary assistance to the men and agents of the Vidhannagar Municipal Corporation to comply the order passed by the court. Stop. The police shall use reasonable force for vacating the portions constructed unauthorizedly in aid of demolition. Next.
220, my lord, I am appearing on behalf of the petitioner. I am for the corporation. I have the report with me, my lord. After passing your lordship's last direction, my lord, no further steps has been taken.
No further steps.
This is my instruction, my lord. Para 6, my lord. May I get a copy of? Yes. Para 6 and para 8.
Ground and the first floor are occupied. Vacation notice has been
Floor are, being demolished
fourth of
on several dates, but next page is the date for demolition from 4th 9.
third, fourth, and fifth floors have been demolished.
No, my lord, my instruction is
Show me the photograph.
My lord, today, my lord, the petitioner, my lord, and just next page is that we are going to demolish again due to her illness, my lord, he has not come, my lord.
You need to show photograph that the construction still remains, because this is the submission.
My instruction is that, my lord, only just top floor, my lord, some holes
have been made. Please come. Learned advocate for the petitioner submits that the unauthorized construction is still subsisting. Is still subsisting. Learned advocate representing the Howrah Municipal Corporation relies upon the report dated 14th August 2025, prepared by the assistant engineer within bracket building department, Howrah Municipal Corporation, mentioning that demolition work of the 3rd, 4th, and 5th floors have been done. Stuff. The ground and the first floor are occupied. Stuff. Vacation notice has been issued. Further demolition has been fixed on 4th September 2025. Stuff. Learned advocate for the petitioner asserts that demolition of the 3rd, 4th, and 5th floors have not been done completely. Stuff. Paragraph. Hearing of the contempt application stands adjourned till 13th November 2025. Stuff.
No,
An updated report.
Please to fix the matter on September itself, any day, because
No.
I want that the demolition should proceed.
Yes. Updated report shall be placed on the adjourned date. Stuff. Both the parties are directed to produce photographs in support of their respective submissions. And this assistant engineer has joined recently or what?
Only
Because previously it was in charge.
In charge, but in charge, that is in charge. But
here he has not mentioned in charge.
That is not mentioned, but he is assistant engineer, but he has joined 5 to 6 months.
He is there. All right. No, because he has mentioned that the
assistant engineer, not in charge.
No, apart from that, he has mentioned that there are a number of street dogs and notice of vacation has been given. And notice is given to dogs nowadays or what?
No. On the actually G+2 that is occupied. Now what happened when the 3rd, 4th, and 5th floors are being demolished? These G+2 occupants are disturbing very much.
They will disturb. And go and demolish their structure. Yes, so dogs are there and you have issued notice of vacation to the dogs. I was surprised.
That is his very good English knowledge because of that. Grateful, Your Lordship. So, my lord, returnable date on
13th of November.
13th November. After vacation. আপনি আছেন?
হ্যাঁ।
বলুন এবারে পেয়েছেন? রিকোয়েস্ট হয়ে গেছে?
আমরা অ্যারেঞ্জ কন্টেন্ট আপনারা আমরা তো নই।
Lordship, in this matter, I beg to appear for the petitioner, Lordship. Lordship, in compliance of the last order passed by your Lordship, I have served the copy of the petition to the state advocates. One of my colleagues is there. He will submit the affidavit of service before your Lordship.
All right, Mr. Torun Ghosh and Rupsha Chakraborty both are here.
Lordship, as per the last instruction received from my client, Lordship, the 1 month's pension has been credited to his account. Last month's pension.
That means now she will get it on regular basis.
But Lordship, no gratuity has been paid and no arrear pension has been paid.
All right, gratuity and arrear pension. State respondents, gratuity and arrear pension.
Arrear pension, corporation will release.
We are not alleged contemners, Lordship. No, I know. The PPO was issued, but payment was not made. That is the reason the court directed the petitioner to serve notice. Right? So, if the PPO is there, then why will money not be disbursed?
Money will disburse corporation.
PPO, PPO is issued by the state respondents,
Ah,
right?
that.
PPO is issued by the DPPG's office. Now the money will come from the corporation or money will come from the state. It is infighting between two of you. Go and fight. But the employee has to receive
not
the
suffer.
payment. Yes.
Yes.
So payment. Take steps, whatever is required to be done. Please come. Learned advocate representing the petitioner submits that only a month's pension has been credited in the bank account of the petitioner. Stop. The arrear pension and the gratuity amount has not been disbursed till date. Stop. Learned advocate representing the corporation and the state respondents shall intimate their respective clients that the dues of the petitioner must positively be cleared prior to the adjourned date. Stop. Hearing of the contempt application stands adjourned till 13th of November. Please do whatever is required to be done. Mr. Banerjee also.
But I have already
I'm obliged, Lordship.
given all papers. They have released the PPO, but they are not releasing the money. That they should do. That will November.
Yes.
Duration was
Mr. Kaushik is appearing for the petitioners. My lord, his wife is unwell. He has taken her for medical checkup, my lord. I'm only praying for today's accommodation.
I have served the copy of the undertaking. I was directed to file an undertaking, giving details of the shop room to be provided to the shop owners.
Yes.
And I have given this affidavit served upon the kindly keep it on the record. And I, in the earlier occasion, you will also will find that the sanction plan has been annexed. In the sanction plan, the shop room number has been
Accommodation has been sought for on behalf of the learned advocate representing the petitioners. Stop. Learned advocate representing the contemner
yes
files an
Undertaking.
affidavit
undertaking, my lord.
files an undertaking by way of affidavit. Stop. The same is retained with the records. Stop. The parties shall make necessary submission on the adjourned date. Released for further consideration on 11th September.
My lord, let him serve the copy on the advocate for the petitioner.
Certainly.
LK Maiti, clerk received from Sanjit Kumar.
Okay.
Certainly he will serve. If not served.
Served on my copy.
Grateful, my lord. I'm grateful. I mean, I'm
Grateful.
My lord, I am appearing on behalf of state, my lord.
On behalf of the petitioner, my lord.
Yes.
Yes, my senior Vimal Kumar Shahi will be appearing.
Oh, he's there online. But then the corporation is there. Where is Mr. Nag? He was here just now. Mr. Tirthankar Dey was there. Call him, call him. He must be there outside.
Lord, then, my lord,
Has the order been complied? Yes.
My lord, the lordship order is already complied, my lord.
Likun, learned advocate for the petitioner submits that the order of the court has been complied with. Stop. The report by the Inspector in charge, Bidhannagar South Police Commissionerate, dated 14th August 2025, filed in court is taken on record. The contempt application stands disposed of. Next.
Deeply obliged, my lord.
My lord, I am appearing on behalf of Kolkata Municipal Corporation, led by Mr. Alok Ghosh. But on the last occasion, we had submitted a report. Your lordship was pleased to direct
For the petitioner.
the petitioner to take instruction.
Yes.
Client file.
No record of the building sanction
Yes,
plan
Your
for
Lordship.
the health center.
Notice
The
that is
special officer. Order of retention has been passed. 401 steps taken and thereafter order of retention upon payment of fees.
Yes.
Has fees been paid?
No.
Then?
Then you should 30 days has passed. Your lordship would see the demolition order. 30 days time was given to them.
If fees has not been paid, then you take steps for demolition.
Give 1 week time so that we can take instruction.
What more instructions,
My
Lordship?
lord, then on next week your lordship will pass on.
Please come.
Your Lordship would see this order was passed on 21st March 2025, Your Lordship.
The special officer within bracket building of the Kolkata Municipal Corporation passed a conditional order for retention of the unauthorized construction. Step. Direction was passed for payment of retention fees within a stipulated period of time. Stop. The time period within which the fees was to be deposited has expired. Stop. The fees has not been paid. Stop. The same implies that the corporation the same implies that the protection given by the special officer building no longer remains, and the corporation ought to take steps for demolition of the unauthorized construction. Stop. Hearing of the contempt application stands adjourned till 13th November 2025. Stop. Steps taken by the corporation shall be placed before this court on the adjourned date.
13 November, they will not take any steps. They have been delaying the entire process. All this time, they have been seeking adjournments.
Yes.
Your Lordship would keep it in the month of September, Your Lordship.
Within September, they cannot take steps for demolition.
Yes. Within this period, you will take steps for demolition. If
Come with the demolition order
lordship,
and the not only order will be there because they have failed to deposit the money. So you have to go there and demolish it. Actual demolition has to be there.
lordship.
Next. Yes.
Kindly see your lordship's order.
Who is the contemptor and did you serve? Nilanjan Odhikari.
Yes, last occasion appeared. And
Where is Mr. Odhikari? Final order could not be passed in the meantime. The chairman has changed. Final order has been passed.
Final order, my lord, the copy has not even served. An inspection has been done.
Copy not. Give a phone call to Mr. Odhikari. I'm passing it over. Call him.
All lordships are urgent for the day. All lordships are urgent for the day.
Why?
I try my level best if he not.
You first call him. Next.
I am for the petition, my lord.
Yes.
My lord, in last 3 occasions, corporation paid for time to complaints report.
Not.
No, my lord. Till yet, nothing has been.
Call Mr. Shaunak Bhattacharya.
Yes,
Call Mr. Shonu. See, his colleague was there outside. Just now, call him. Next. Call the next one.
My restoration application, madam.
Yes.
Madam,
When was it dismissed?
4th August, madam. I'm really sorry I couldn't be present, but I was on legs.
All right.
So was my advocate. Madam, kindly pardons us, madam, and restores the matter, madam.
All right. And what is the matter about?
But this is regarding allocation of a coal.
Who is your other side?
Mr. Dheeraj Trivedi.
Did you serve the application?
Yeah.
You served?
Yes. Also
Nobody is there. Mr. Orijit Mujumdar was there in the morning.
We have refused, so we had to serve it to the department. We had to serve to the department because they have refused. We have served that.
Oh, they have refused service?
Possibly because it's an application. I don't know whether they have the instructions separately for the application or not. That's their internal thing. I do not know. But we have served. Your lordship would kindly see we have served the respondents also.
Restored. The matter will appear in the combined list September.
Your lordship is restored.
Let notice restored. Let notice be served upon the learned advocate representing the respondents. Next. I can dispose for you. Next. Service is taken on record. Yes, it is.
Number 2.
What is it?
The matter was dismissed for default.
Restoration? Very well. Yes, I can see what maybe can do is an application for restoration. Dismissed. Record your appearance.
My lord, 226
Restoration.
present here, Mr. Sholam Hotel.
Yes.
Was engaged me not before.
Can 2 is for restoration. Can okay, এটাকেও ডিসমিস করে দেবেন। আর যদি মরে গিয়ে থাকে তাহলে তো মরে গেছে। বোথ ডিসমিসড। কোথায় গেল ওনার মামলাটা? Did you pass order?
Milord, order has been passed. Milord, what happened, Milord? There is no regular Milord commissioner in our corporation. It's
Yes.
only to be signed by next week, Milord. Order will be communicated to them.
Where from will you get the commissioner?
Milord, he has been now, Milord, the secretary of the Adda has been given the dual charge.
All right.
Milord,
So by next, please come.
Milord,
What is the item number?
226.
And Milord, simplicity, post it, Milord, next week, Milord, it will be.
226. Learned advocate appearing on behalf of the Asansol Municipal Corporation / contemner submits that final order has already been passed and the same will be communicated to the petitioner by next week. Paragraph in view of that submission, release the matter on 4th of September. 4th September.
Yes.
Yes, call.
Before my lord takes item 229, 223, my lord, I missed the, my lord. Order has been complied with, my lord. For the
It's only your appearance that has not been recorded. Otherwise, everything else has been recorded.
it has been complied with, my lord. Kindly.
Give whatever you've got. You've got something.
Will I have telephonic instruction?
Telephonic instruction.
It has been
Very
complied.
well. ওনার নামটা একটু দিয়ে দেবেন তো? Yes.
223, 223. 229, I am for the alleged contempt. My lord.
Yes. What happened?
Sorry, my lord, I require some more time because on twice, my lord, that is on 14th of August and my lord 18th. The police requisition has been sought for, but as per my instruction, I did not receive any, my lord. We did not receive any reply from the police authorities intimating the date. Perhaps my learned friend would, my lord.
I deny because just now I have taken instruction that tomorrow they have fixed the date. We are ready with our force to assist that. Earlier to date, my lord,
I have whatever.
I vehemently oppose this.
Whatever documents I have, my lord.
They're trying to shift this burden. That is not at all, my lord, a good gesture from this one of.
My lord, whatever documents I have, my lord, I am submitting on the basis of the.
Are you aware that tomorrow is the date fixed for demolition? No?
No.
Show me the document
Kindly
that
pass
tomorrow
it
is the
over
date.
for a while, my lord. I shall, my lord.
I'll pass it over. Very well.
Kindly pass it over.
You also get the communication that tomorrow is the date fixed. Pass over. 230.
230, my lord, I am for the.
My lord, in item number 230, my lord, Mr. Hon'BLE is appearing, my lord. My lord, he is on legs at before his honorable judge, my lord. My lord, Joy Gupta, my lord. My lord, kindly, I am.
Has the order been
not
complied?
No. My lord, it has been referred to the Board of Council, my lord. Board of Councillors have conducted a meeting, my lord. Yes, my lord.
Which
Board of Councillors
municipality? Which municipality?
My lord, Arambagh Municipality.
All right.
Arambagh Municipality.
Referred to the Board of Councillors.
Yes, my lord.
Any hearing?
My lord, meeting has been conducted, my lord, but my lord.
Was the petitioner given notice of the hearing?
Already, my lord, kindly look into their report, page 24, that they have stated অবৈধ নির্মাণ করিয়াছেন।
And that is long over. Now they will take fresh steps.
10 দিনের মধ্যে পশ্চিমবঙ্গ সরকারের আইন অনুসারে ভাঙার ব্যবস্থা গ্রহণ করুন।
My lord, it has been referred to Board of Councillors, my lord. As per my instructions, Board of Councillors have conducted the meeting, my lord. My lord, there are some facts, my lord, that Mr. Hon'BLE will place it before your lordship, my lord. Kindly makes it not.
Learned advocate for the petitioner submits that the order of the court has not been complied with till date.
Pressurized me, my lord. Municipality pressurized my client, my lord.
For what?
That I have a old 50 years old building, notice upon me and said your building also illegal.
Learned advocate representing the
Contemner, my lord.
Municipality / contemner seeks accommodation. Stop. It has been submitted that The matter has already been referred to the Board of Councillors. Stuff next. In view of such submission, hearing of the contempt application stands adjourned till 4th September 2025. Stuff. An affidavit of compliance shall be filed on the adjourned date.
Already compliance filed.
Already filed one, another complaints.
Next.
Gratefully, Your Lordship.
Actually, I am for the contempt, Your Lordship. Actually, we have
Lordship, kindly come Lordship's order at page, Lordship's order at 13th February 2025.
Lordship, a compliance report has been filed, Your Lordship.
And Lordship, this is my exception.
And they have filed an exception, Your Lordship.
Yes.
Lordship, kindly come Lordship's order at 13th February 2025. Lordship, the learned, may I place this order, Lordship, so the clear of the picture.
13th February
2025.
2025. 13th February, yes.
Learned advocate representing the Pradhan of the Gram Panchayat has produced a copy of the order dated 30th September 2024, wherefrom it appears that even though the Pradhan...
Oh, 1 minute, I can read it. All right. Yes.
Now, post approval has been discarded by this honorable court.
Yes.
That they have no right to post approval. Now, Lordship, kindly come to the compliance report.
Lordship, kindly come
Even
to
after that,
27th
this
of
is
March,
act of
Lordship's
contempt.
order. I think, Lordship, that would be the ideal.
Anyway, that is there in your compliance. It must be there in your
Yes, Your
compliance.
Now,
Yes, Your
Lordship, kindly come to the compliance report.
Yes.
Lordship, may I place the compliance report?
No, please, 1 minute. You will get a chance.
Now, like, kindly come to the compliance report, paragraph 3. At the outset, Lordship, first of all, Lordship's post approval has been set aside by your Lordships. Now, kindly come page 3. At the outset, I beg to submit most humbly that the writ petitioner filed a contempt application to compliance of the order dated such and such, passed by the Honorable Justice such and such. At the time of hearing the aforesaid contempt application, this honorable...
Wait, please wait. Director spot inspection. It has been resolved that the building plan approval is irregular due to non-reflection of the building permission fees on account of such and such. Refer to the SDO for taking action. Yes, where is the difficulty?
Lordship, kindly come page 6.
Yes.
Official record যাচাই করে দেখা গেল যে 8/4/2017 তারিখে শ্রী বিনয় কৃষ্ণ বেরা ইস্যু হওয়া বিল্ডিং প্ল্যান Lordship, kindly come. This is
Yes. Sanction planner
অনিয়ম বিবেচিত হয়েছে. Now, Lordship, kindly come the page 7.
Yes.
Lordship, this second paragraph from the bottom, wherefrom it Nirman Sayak Sri Amitabh Mondol have confirmed that authenticity and genuinity of the building sanction order and the sanction plan.
And Lordship, kindly come to page number 14 of the letter that has been issued by the erstwhile Nirman Sayak.
Now, Nirman Sayak, Lordship, we have, Lordship, annexed the letter in the writ petition, the Right to Information Act. They have supplied the information. This same Nirman Sayak, that no sanction plan has been issued. Not only that, Lordship, kindly come, my exception.
Listen, show me from the documents that it has been forwarded to the subdivisional officer.
Lordship. This is the receiving copy that it has been forwarded on. A mail has been also been sent on 18th of June, Your Lordship. It has been sent and it has been received, Your Lordship.
You did not annex it with the compliance?
No, Lordship. It has been done afterwards, Your Lordship. So that's why it was not annexed, Your Lordship. It has been forwarded, Your Lordship. Now.
See, the subdivisional officer is the ultimate authority to take a decision. You follow it up, please.
Now, Lordship, only one
Deeply
thing,
obliged.
I I'm praying for Lordship, let this statement be recorded. Kindly keep page 7 of my, this is exceptions to the page 7. 23rd June 27, the concerned panchayat issued the stop work notice. That has been suppressed by this panchayat.
All right.
And Lordship, next page.
The matter relates to unauthorized construction in a panchayat area. Stop paragraph. The Pradhan of the Gram Panchayat has forwarded all documents to the subdivisional officer. Stop paragraph. The petitioner is granted liberty to follow up the matter with the subdivisional officer. Stop. The subdivisional officer shall afford an opportunity of hearing to all the necessary parties for production of all documents in support of their respective stand prior to passing a final order in the matter. Contempt application stands disposed. Exception of the petitioner filed in court today is taken on record. Stop. The communication of the Pradhan of the Gram Panchayat dated 18th June 2025 addressed to the subdivisional officer be also written with the records.
Lordship, I'm praying for let subdivisional officer take a decision within a certain period.
Lordship,
Kindly, because long time petitioner is
The contempt matter and can fresh direction be passed?
as at least as expeditiously as possible. Lordship. This is, I am expected. Lordship.
Subdivisional officer shall endeavor to dispose of the matter at the earliest.
Great.
Lordship, liberty may be given to get that copy, Your Lordship, that what I've supplied, Your Lordship, that transfer of application that was sent to the SDO. That copy, that is the original copy that I've given to the court.
Give a photocopy.
Photocopy the original.
Photocopy.
Where is
I'll give a photocopy. I'll give a photocopy. Your Lordship.
Do you have one with
I
you?
don't have one, Lordship.
All right, you take this back.
I'll give a photocopy during the.
নয় আমরা ফটোকপি করে অরিজিনালটা ওনাকে ফেরত দিয়ে দেবো শুধু প্রথমের 1 নম্বর পাতাটা যেটা অরিজিনাল আছে ফার্স্ট পাতাটা এটাকে একটা পাতা জেরক্স করে রেখে দিয়ে অন্যটা দিয়ে দেবেন নেক্সট
For any grateful.
I'm for the Lordship, I am for the petitioner. I'm requesting for a day's accommodation, Lordship. I'm led by Mr. Moyuk Mukherjee. He is in circuit bench and tomorrow he will be there in the principal bench, Lordship.
Is that a ground for seeking adjournment?
No, Lordship, I
It's
understand.
not a ground.
Still, this is what I am instructed, Lordship. Kindly consider my request, Lordship.
Only review matter.
This is
I think review.
application for review. When you seek adjournment, you should know the grounds on which adjournment may be allowed. The ground that you have stated is not a ground for adjourning. Right? So what is to be done?
Lordship, just for one day, Lordship. Tomorrow he will be there, Lordship.
Where is the advocate on record?
But I have no idea about that.
You do not have any idea? You are mentioning? Who
Lordship.
has instructed you to mention?
Lordship, I just joined this chamber in a very recent. So actually, I don't have.
No. And that is the reason you are so naive and it is showing. But who has instructed you?
Lordship, one of the junior of chamber.
One of the juniors. Who is that junior? Bring. Let me see who that junior is. Just pass it over. Please call the next matter. Yes.
I'm for the contempt now. We prefer an appeal, we lost there. Appeal has been dismissed, my lord. This is the order, may I be? For compliance.
You are taking steps for compliance. When was the order passed?
Order passed in 2023, my lord. After appeal was.
What was the direction?
Direction was that, my lord. Demarcation of the land and if found we have acquired the land. Utilize the land. Utilize it, we will pay the company. We have to pay the compensation.
Against that you prefer appeal?
My lord. Because my lord, our ground was that the land actually does not physically belong. There is no land actually.
Then what happened? Land was found.
No, the Honorable Division Bench directed us to hold a hearing to inquire into the matter whether there is
Thereafter, you should have taken a decision. I do not know.
decision of the
Come.
authority, my lord. I am a creature of instruction, my lord. Nothing can be done.
And
But then you also advise as to whether this is a good and valid ground, because
It's not an appealable order.
you have to sign.
It's not an appealable order.
In the memo, you are signing that these are the good and valid
grounds
grounds
of
for appeal. It is your signature. The authority will not know.
On the by the last order, my lord kept today for filing compliance report.
My lord, just few
But
days back it has been
going
dismissed.
Division bench's order, let me see.
Yes, thereafter, my lord, we have just after the division bench's order, we have issued notice.
On 13th August, division bench dismissed their appeal.
On 14th,
14th, they have issued a notice.
On the very next day.
25th is the date.
Learned advocate
Kindly keep it for the compliance.
appearing on behalf of the contemptor submits that the appeal preferred from the order passed by this bench has been affirmed by the Honorable Division Bench on 13th August 2025. Steps are being taken for complying the direction passed by the court. Some time has been sought for. In view of such submission, hearing of the contempt application stands adjourned till 13th November 2025. An affidavit of compliance shall be filed on the adjourned date.
Much okay.
Pass over. 229. 229. Yes.
Much okay.
Yes.
We did not receive any reply from the end of the police. However, twice we have intimated them, intimating the date of demolition. Admittedly, the date of demolition is fixed on 22nd, but the reply as to whether they are going to provide us police assistance or not on that particular date, we did not receive any reply.
What is your submission?
That will kindly take my 2 reply letters.
On 14th itself, we have communicated that we will provide assistance on 22nd. Well, there are communications, my lord. On 14th, on their letter, we have endorsed that on 22nd, we will provide the assistance.
And please come. It appears from the submission made on behalf of the corporation and the Bidhannagar Police Commissionerate that 22nd August 2025 is the date fixed for demolition, and the police will render all necessary assistance to the men and agents of the corporation for execution of the order of demolition. The police shall use reasonable force to remove the unauthorized occupants from the portions constructed. Unauthorized occupants have occupants from the portions constructed unauthorized.
The entire building is unauthorized.
Entire building. How many floors?
Miller, it is that matter. Pachiwala Polle Miller, your lordship is direct. So motor contempt has been taken up. 20 number of flats are there. Out of 23 flats have been demolished from the top.
Total 6 has been
Total
6. Out of 29, total 6 has been demolished. 29.
The corporation shall continue the demolition work on day-to-day basis till the entire construction work, till the entire unauthorized construction is demolished. The contempt application is made returnable on 13th of November 2025. Communication made by the executive engineer of the corporation to the Joint Commissioner of Police within bracket HQ on 14th August 25 and 18th August 2025 be written with the records. Same DPPG and everything. They are refusing that. What is the other matter where order was passed? DPPG and DLP was added 270.
270.
207.
217.
217 সুব্রতবাবু 217 এ একটা অর্ডার হয়েছে, সেম অর্ডার এখানে করে দেবেন তো।
But Lordship, in this writ petition, DLB was not party, Lordship. Only
DLB was not the party. DPPG was the party.
Then it will become difficult. Only DPPG কে করলে তো হবে না।
Actually, my lord, in those matters, my lord, Swapon Chatterjee and others, my lord, DLB was not the party, my lord, because there was a direction, my lord, of the director of local bodies. Pursuant to that, DLB said, my lord, no approval is required. So this is why, my lord, DLB was not the party in those writ petitions.
But now DLB is raising objection. আচ্ছা একটা কাজ করুন, ওখানে না ডিএলবি পার্টি ছিল, সেটা লেখার দরকার নেই, শুধু ডিপিপিজি কেই রাখবেন, ঠিক আছে? And here was there any direction for personal appearance?
No, Lord.
No.
ওখানে personal appearance ছিল, সেটা এখানে হবে না। Otherwise everything remains the same. Let us see what can be done.
Matter will appear on the same day.
6. My lord, one undue enter.
I'm grateful.
My lord, item number 280 of the today's list, my lord. Petitioner has mentioned the matter, intimated me through a letter, my lord, just now.
280?
280. Contempt application, my lord. I have to leave now, my lord, for some reasons.
Yes, possibly it was mentioned. এটা কি allow করা হয়েছিল? Allow হয়েছিল? Who is assisting you?
My junior Indumoli Banerjee, our son is also suffering from illness. He has not come.
In that case, you intimate the learned counsel. I do not remember who mentioned.
I
It
know
will-
him. I know him.
You know him. Next Thursday, it will be upgraded.
My lord, grateful.
Please intimate him.
I will just know.
The DPPG made a party in the contempt process.
হ্যাঁ ডিপিপিটি কে ওটা আগেরটাতে দেওয়া আছে, আগেরটাতে আছে। হ্যাঁ হ্যাঁ। Yes, call the next one.
But I appear for the contempt, lordship. KMC.
For the statement.
KMC.
Has
My
the
lord,
order
order
been-
was there, my lord. It's a
My lord,
5-story building.
officer in charge, my lord. Kora police station, my lord.
Yes, has the order been complied?
Yes, my lord. Fifth floor has already been demolished with the.
What is the corporation stand?
No, my lord, according to my instruction, my lord, the attempt is continuously being made, but not yet
cannot.
100% successful we are, because a 5-story building, another construction at the top of 5-story.
Fifth floor.
And my lord, whenever we are making attempt, my lord, all the occupants, they are harrowing us. And rainy season, people are there. Some are, my lord, crying. There, I will be ousted. We are trying our best, but we are being, my lord, disturbed time again and again. That's the situation. Under these circumstances, my lord, this is the report. Kindly have a look to this, my lord.
Please come. The order of the court has not been complied with till date. Stop. The unauthorized construction still remains. Stop. Submission of the corporation is that those steps are being taken for demolition of the unauthorized construction, but because of the resistance of the occupants
And the people residing in the, my lord, premises. Another
and
portion, yes.
the
They are-
people residing at the subject premises
Madam.
are restraining the officers from proceeding with the work of demolition.
This is one part. There was very strong direction of the concerned police and, my lord, higher authorities.
Yes,
You make the premises vacated.
right.
That is not completely done. Kindly, my lord, see that.
My lord.
That part has to be looked into.
There are 5 of my report, my lord. Complaint has been already. He's registered a case number such and such, my lord, against such and such persons, my lord. Police has already taken steps.
আচ্ছা লিখুন তো। The officer in charge Koraya police station has forwarded a report signed on 7th August 2025 mentioning that the corporation demolished portion of the top floor and the 5th floor within brackets ceiling, wall and floor of the unauthorized portion of the subject premises with due assistance from the police. Step. CESC has disconnected electricity of the mobile tower situated at the top floor of the subject premises. Step. Paragraph D. On the basis of a complaint of the petitioner, police case has been registered against 3 persons, being Koraya PS case number 176, dated 5th July 2025, under section 351, within bracket 2/3, within bracket 5, BNS. Stop. The investigation of the case is in progress, and the police is maintaining strict vigil to ensure that the life and property of the petitioner is not hampered. Stop. Paragraph. As the corporation submits that because of the resistance of the the unauthorized construction cannot be demolished, accordingly, completely demolished. Accordingly, the officer in charge of the Koraya police station is directed to seek from extra police protection from its higher authority so that the corporation is able to conclude the demolition at the earliest. Stop. The police shall use reasonable force to disperse the crowd that may accumulate at the time of execution of the demolition work. Stop. Paragraph. Hearing of the contempt stands adjourned till 13th November. Let this be written with the record.
13th or 30th?
1-3.
I'll get you.
Achha. The
May not be unlucky.
report of the engineers of the corporation signed on 21st August 25 be written with the records.
Not I pray, let it not be not unlucky to us, for us.
Yes.
Let it not be unlucky for us, 13th.
I do not know.
That I only
Yes,
pray.
it is not done. Then it may be unlucky also. Next. Yes.
I'll number the state respondent, my lord.
For the petitioner, Lordship. Lordship, there was a direction for demolition of the entire building. The entire structure is illegal. There is no sanction plan. Now, corporation has come twice for demolition, but the work they have done, this is the work. It has been taken today morning, Lordship. And moreover, the police personnel who was there, who has come there, he came to our house and has said to negotiate the matter with the private respondent and to withdraw the complaint.
This is, my lord, from the bar. My lord, kindly see my report and picture. That picture will be actually.
Lordship, this is the complaint which we have made, police complaint on 8th, and the private respondent on the other hand is threatening us constantly.
Yes.
But here is my report.
Let me see.
What is actually the matter pending before the learned additional district session judge? There was a stay up till 1st July 2024. And thereafter, my lord, if you lordship skip over, and that is the last 4th paragraph along with my photograph. Probably my learned friend actually took the picture from outside.
Your photograph also shows that walls are there, the pillars
Only,
are there, the columns are there.
That is the concept, because the top floor to ground floor.
Yes, yes.
Yes, your lordship kindly see, my lord.
I can see it.
My lord, only the walls are there.
Walls are there.
Third. everything gone. Now we will
Yes.
actually demolish. The next day
Yes,
the demolition is-
continue with the demolition. Continue with the demolition.
That is, my lord, that is, my lord, the appellate court order. Your lordships kindly see that stay order was there. We are actually
Till
constant.
24, you say?
That is July 24.
So we are in
And
25
thereafter, my lord, your
August.
lordships kindly, my lord, with deepest respect, my lord, on the last occasion, my lord, my learned senior, my lord, Arugh Ghosh submitted that, my lord, that picture regarding the stay order is there or not, that cannot be.
Why are you going to 24? We are in 25 August.
My lord, that is the actually real scenario. The only thing is this, my lord, after demolition.
Real or unreal? I do not know. Please come.
Only give some more time because.
All right, I'll give you some more time. Report of the engineers filed in court. Signed on 21st August 2025. Be written with the records. Stop. Photograph has been annexed with the report to suggest that demolition work has been done to some extent. Stop. Prayer has been made to extend the time for concluding the work of demolition. Stop. Paragraph. Learned advocate for the petitioner submits that the police is pressurizing the petitioner to enter into negotiation with the person responsible for making unauthorized construction. Stop. The petitioner has lodged complaint before the police. Stop. Paragraph. The court is taking serious note of the submission made by the learned advocate for the petitioner. Stop. The police does not have any authority to advise the petitioner whether to enter into a negotiation or not. Stop. The unauthorized construction which remains is liable to be demolished. Stop. Hearing of the contempt application stands adjourned till 13th November 2025. Stop. Affidavit of compliance shall be filed on the adjourned date. Stop. It will be open for the petitioner to place updated photograph on the adjourned date. The police is directed to ensure, the police is directed to ensure that no harm is caused to the life and property of the petitioner at the hands of the person responsible for making unauthorized construction or his men and agents in any manner whatsoever. Next.
May it please your lordship.
Yes.
I am for the petitioner, my lord, with utter despair. My lord, I am filing this exception to the so-called report. My lord, the building still stands, and even today, my lord, your ladyship.
Yes.
The building still stands even today.
And?
As of now, no demolition has been effected.
No demolition?
None.
How big is the construction?
My lord, there are lateral deviations to a greater extent and 3 extra stories over G+2.
G+2?
G+2 is the sanction building plan and 3 extra.
May I submit, madam?
Yes.
Let a special officer be appointed now.
All right.
We have done the demolition. 100% demolition
This is
required.
today.
Yes.
This is today.
100% demolition is required to be done, but it requires some time because there are occupied portions in the building. The persons in the sanction portions are also there. So we are facing these problems with the persons occupying in sanctioned portions.
Yes.
So, my lord, some time may be given. I have already told the engineers, and many demolitions are being carried out. Mainly the demolitions which are being court contempts.
All right, please come.
So, some time may be given. my lord.
Learned advocate for the petitioner submits that the unauthorized construction still remains. Stop. Paragraph. Learned advocate representing the corporation has received instruction from the assistant engineer within bracket building department signed on 31st July 2025, which mentions that the part demolition has been done. Stop. Some more time has been prayed for to execute the entire work of demolition. Stop. Paragraph. The the hearing of the contempt application stands adjourned till 13th November 2025. Stop. The unauthorizedly constructed portions shall be demolished prior to the returnable date. Stop. The Commissioner Howrah Police Commissionerate is directed to render all necessary assistance.
They are assisting, madam.
They are assisting.
Kindly, leadership kindly keeps it. Kindly keeps it because not a single brick has been taken down till date.
Acha. It will be open for the petitioner and the corporation to produce updated photographs on the adjourned date.
13 November.
13 November. Exception by the applicant to the report filed by the petitioner be written with the records. Petitioner na corporation. Next.
Grateful.
I appear for the petitioner, my lord. But pursuant to your lordship's order on 24th of July, my lord, the state has taken time, my lord, to get the property vacated for the purpose of demolition, my lord. Today, my lord, my instruction is that it has been, my lord, vacated by, my lord, the unauthorized persons who were there, and, my lord, certain part has been demolished, but the building structure is still there. It is required to be, my lord, completely demolished. Otherwise,
yes, please.
While I am filing the report, my lord, kindly see the photograph of the building.
Can I have a copy?
Yes, photograph of the building shows that some demolition has been done, but then the outer structure still remains. This has to be demolished.
My lord,
Correct.
my lord, here is KMC's report, my lord.
Please give.
Actually, we photograph is separated by the damage. Maybe excuse lordship.
Yes, it is the same photograph. The outer structure is remaining.
In the sense, my lord, nothing, your lordship's last order, and within this span of that is.
Very well. Now I extend the time, demolish the whole thing. Let's come.
Right.
From the report filed by the engineers of the Kolkata Municipal Corporation and the police, it appears that partial demolition work has taken place. Stop. The outer superstructure, however, remains. Stop. Hearing of the contempt application stands adjourned till 13th November 2025. Stop. An updated report with current photographs shall be annexed in support, annexed to show that the construction has been demolished completely.
Great.
Unauthorized construction. আচ্ছা এটাকে একটু স্টেপল করে রাখবেন তো জানাবো এটার সাথে এই ছবিগুলো yes next
Great.
May it please the lordship, my lord, in this matter, my lord, the Domdom municipality, they are supposed to inspect a property, my lord, instead of doing that particular, they inspected in a different place.
Different place?
Different place, different DAG number altogether. That reflects your lordship's last order dated, my lord, 20th of February.
Yes.
My lord, specifically directed to take necessary steps in regard to other plot numbers which are connected, my lord, concerned LR plot number. My lord, thereafter, my lord, they inspected, but though they did not file the report, but I have
LR plot numbers 2095 and 2098.
My lord, through RTI, I have come to know. Through RTI, I have come to know they have
Why
taken.
you did not go to inspect? Was notice not given to you?
Yes, no. They, my lord, they inspected with a plea. They have come up with a plea. My lord, kindly see the order. Through RTI, I have come to know no formal order was report was served upon me. Wherefrom it appears that the LR map was not available to them. That is why they approached the BLRO to provide them LR plot. So that till right as of now, my lord, kindly give a specific direction so that they can come up with that report so that matter can be disposed
The
of.
inspection was carried out in presence of the BLLRO. My lord, the report was submitted to the municipality. From the report, it was found out that the particular land was of a different number and the land belonged to the Metro Railways. Now, my lord, thereafter, my lord, the municipality wrote a letter to the BLLRO for giving proper clarification with regards to that land. My lord, he has not communicated as of yet, my lord.
No, but then it is you who is the contemptor.
Lordship.
And the court is going to hold
Sir,
you.
until and unless, my lord, the plot is identified, my lord, we cannot carry out the repair work or, my lord, the construction
Follow
of
it
a.
up with the VLR so that it can be
That was-
identified and
Lord,
matter
may-
can be disposed.
Some initiation from their end can
some
sort
time
out
may
the
be
issue.
given, my lord.
Please come. Learned advocate appearing on behalf of the contemptor submits that communication has been made with the Blockland and Land Reforms Officer for identification of the plot of land, which is required to be inspected. Stop. There is no communication from there is no response from the end of the BL and LRO. Stop paragraph. The contemptor is directed to follow up the matter with the BL and LRO so that the order of the court can be complied with at the earliest. Stop. Hearing of the contempt application stands adjourned till 13th November 2025. An affidavit of compliance shall be filed on the adjourned date. Yes.
I'm for the contempt.
Order complied?
No,
No?
Not complete.
Order complied?
Yes, madam.
No, no, your lordship, can you see the report just now? I have been handed over.
What was to be done?
Lord, I was directed to take step for compliance of the order. Lord, it's a two-story building.
Yes.
Subsequently, my lord, HOB, my lord, passed an order for demolition of the top floor. And subject to payment of fees, my lord, the rest portion, that is, my lord, first floor was, my lord, ground floor was, my lord, directed to be regularized. My lord, they didn't comply with the order. Accordingly, my lord, we carried out demolition proceeding, my lord, in respect of the top floor. And so far the rest portion is concerned, my lord, this is occupied, and that's why we have given notice under section 412 subsection 1 of KMC Act for vacating.
When?
It's for the police, my lord. Okay.
When was the notice given?
Even the top floor, according to them, has been partially demolished, not fully demolished.
My lord, your lordship, kindly page 9, my lord.
Page 9. Yes, what is page 9?
My lord, it's on 16th of April 2024, my lord. Notice for under section 554 and 546 was given, my lord.
Yes, thereafter?
Thereafter, my lord, vacating is required, and that's why, my lord, help is required from the police authority. My lord.
Yes. Did you seek assistance?
My lord, yes, my lord. Yes, my lord.
Where is the document to show?
That I've found.
Police cannot go there suo moto till you seek their presence, their assistance. Isn't it?
Yes, my lord.
Then, where is the document? Please come. The order of the court has not been complied with till date. Stop.
Lordship, kindly takes up last.
The unauthorized construction still remains. Stop. According to the corporation, as the portions constructed unauthorizedly are occupied, accordingly, the demolition cannot take place despite notice of vacation issued upon the occupiers. Step next. The from the compliance report that has been filed, there is no document to suggest that the corporation sought the assistance of the police for implementing the order of demolition. Stop paragraph. Hearing of the contempt application stands adjourned till 13th November 2025. Stop. Further affidavit of compliance shall be filed annexing photographs to show the demolition that has been done. Stop. The petitioner may also produce photographs of the unauthorized construction, if any. Construction, comma, if any. Compliance is taken on record. Call the next matter.
For the petition.
Yes. Yes. Order complied. Just now you're receiving the compliance.
There is a, after this affidavit, there was a direction for calling the person responsible and the complainant. When this affidavit was affirmed, that part was not complied. Subsequently, they were called. A fresh order has been passed. That report I'm also having with me. Your lordship kindly sees that, and this portion
The compliance report, my lord, only, my lord, the direction for demolition is there.
That is in June 25, it was affirmed. He has documents thereafter.
That too, it was on April 25.
April 25's order.
So for the subsequent parties concerned, may I come back with a fresh affidavit of compliance? Because there is a
documents. You have it with you. Cannot find it offhand.
Since all the subsequent matters up to 245 are in the same name, he possibly has mixed up.
Same name?
Same name. 43, 44, 45 also.
Oh.
Your lordship kindly turns up page 7 of this affidavit. So for this one, this is complied.
No, it will not do because it was in June and you said some steps have been taken
In
thereafter.
respect of rest matters, it is done in this matter.
7
April.
April.
Again, as per the order of Honorable High Court dated 26/9/2023, hearing has been taken before
thereafter,
after serving notice to the parties, the respective persons.
Demolition order has been issued.
Demolition order was issued, when the writ petition was taken up. Prior to that, your lordship direction was to call them and pass a fresh order. Your lordship kindly takes up the order passed by your lordship.
Page 7, you say last paragraph, after hearing, demolition order has been issued against the unauthorized construction directing demolition of the unauthorized building. Thereafter, nothing done.
Direction was that to call them and pass a necessary order. Your lordship kindly takes up that part of the order.
It should come to a logical conclusion. Otherwise, my lord, the order for demolition will become meaningless.
Keep this in mind when you appear for the corporation.
Yes, my lord. Always, my lord. I never make any submission, my lord, which is correct.
It can cut both ways.
Yes.
Today you are appearing for the petition and tomorrow you will appear for the corporation. It's the same thing.
We are, my lord, with this liberty as much as we have, my lord. কিভাবে রেখেছো?
Direction was to deal with the unauthorized construction in accordance with law. That does not mean only passing an order of demolition and sitting tight.
By the time it was taken, the order for demolition, your lordship kindly sees the first part of the report.
An affidavit of compliance by the corporation.
In 2019, the demolition order was, but at the time of
affirmed the order on 26 June 2025 has been filed before this court. It appears therefrom that unauthorized construction has been detected. An order of demolition of the entire unauthorized building has been passed. The follow-up steps taken by the corporation to actually implement the order of demolition shall be placed before this court on the adjourned date by way of an affidavit. 13th of November 2025. How big is the structure? How big? Structure is how big? You do not know. Because it is mentioned the entire building is unauthorized.
Yes, my lord, it was there, my lord, at the petition stage. I was not there.
All right. Doesn't matter. Yes, next.
My lord, this is also the same, my lord. In this matter, my lord, after my lord, this affidavit, my lord, this is the improvement when your lordship can consider this, my lord. That's
Yeah,
all,
okay.
really.
Along with improvement.
You know.
See the how they have proceeded. Last three lines, the dates I will read out. Demolition program was executed on 7th September 22, 2nd September 23, 1 year. Next is 5th of August 24, another year has gone. Then 7th March 25, another 6 months, and then May 25. So even these 5 dates were not enough for the demolition of the entire unauthorized construction, because by the interregnum between the first and the second days of demolition, further construction is raised. Isn't it?
My lord, your lordship kindly takes the last page of this report, my lord.
Yes.
My lord, this is the order, my lord, which was passed, my lord, and we have tried our level best.
5-storied building.
Yes, my lord.
Bring photograph.
2022, my lord. And my lord, we have tried our level best, my lord, as per our schedule, my lord.
Your level best, it will be seen now. Ashun dekhi. Report of the engineers of the corporation signed on 14th August 2025 has been placed before this court. It appears therefrom that the unauthorized construction has not been demolished. Stop. The structure is a 5-storied building constructed without any sanction plan. Stop. The corporation, now, the manner in which the corporation has proceeded to take steps against the unauthorized construction clearly indicates that the corporation is not taking active steps to implement the order of demolition. Stop. The due to the dilatory tactics adopted by the corporation to adjourn the demolition proceeding. Come on. Is very apparent from the records. Stop. As the entire structure is unauthorized, the same is liable to be demolished without any further delay. Stop. Next. Hearing of the contempt application stands adjourned till 13th November 2025. An affidavit of compliance annexing current photographs shall be filed with advance copy to the learned advocate for the petitioner. Next.
Lord, in this matter, my lord, will be praying for an adjournment, my lord, fixing the matter on the same day as regard other matters, my lord. We have affirmed an affidavit, but my understanding, my lord, there is a dispute, there is statement which may be, my lord, found wrong, my lord.
All right.
My lord,
That means the order has not been complied. Please come. The order of the court has not been complied till date. Pradeep. On the prayer of the learned advocate representing the contemptor, hearing of the contempt application stands adjourned till 13th November 2025. Stop. An affidavit of compliance shall be filed on the adjourned date with advance copy to the learned advocate for the petitioner. 45.
Well, EDT is also there, my lord.
My lord, in this matter also, my lord, the situation is almost same, my lord. After affirmation, this affidavit, my lord, the situation improved, and we have given an hearing, my lord.
Yes. দেখি আর কি দিচ্ছে
That your lordship can transfer the last paragraph.
7th April 25, order of demolition. Nothing done thereafter. Hey, Pradeep. The order of the court has not been complied till date. Stop. The affidavit of compliance and the report by the engineers of the corporation dated 11th August 2025 be written with the records. Stop. The corporation has detected unauthorized construction.
ওই তো অর্ডারটা রিপোর্টটা দিলাম তো
But the same has not been demolished till date. Stop. Hearing is adjourned till 13th.
রিপোর্টটা দিলাম তো
Affidavit of compliance along with photographs shall be placed on the adjourned date. একটা লাইন লিখে নিন তো 4-storied building is constructed unauthorizedly. Yes. Passover কটা আছে দেখি 280. It was mentioned just now by Mr. Shamanto. Next Thursday.
Thursday at the top.
Yes.
25 for the petitioner, I could not find out, my lord.
You could not find out?
I served the notice, my lord, procedure.
None appears on behalf of the contemptor. Stop. Let notice be served upon Mr. Nilanjan Odhikari, learned advocate, who represented the contemptor in the earlier occasion. Stop. Released on 4th of September.
And I am for the state respondents. I indicated the AOR. She is in court number 35. She is on the way, lordship. Just for 5 minutes, lordship. She is engaged in fixed matter, lordship, actually.
Accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. Released on 11th of September. Next.
My lord, I am for the petitioner, my lord. Yes. This is a new content application, my lord.
All right. Please serve. When is the returnable date? 11th of.
My lord, my making in one submission, my lord, there are two containers. But I have filed this content application, my lord, in the year 2022. But in the mind, both the container, my lord, retired, my lord, the new incumbent has.
All right. Leave is granted. You implead the new incumbent. Yes. All right. 11th of September, it is returnable. Please serve.
In the window, my lord, I amend the cost structure after getting the names new incumbent.
Please do.
First time we look at. First time.
Yes, please serve. None appears on behalf of the petitioner. 23 contempt, dismiss for default. Dismiss for default. 607. Dismiss for default.
The order under contempt, the private respondent has preferred an appeal. And this order has been passed, and therefore, the appellate court's order has been merged with your lordship's order. Their appeal has been dismissed.
by directing the appellant not to effect any construction on the property without a proper sanction from the concerned panchayat. Before according sanction, the panchayat shall hear after the since that the construction is effected obstructing. So the order has been modified.
Yes.
So you have to go before the division bench in case there is any. Very well, please come. The order dated 21st April 2025, passed by the Honorable Division Bench in mat number, has been placed before this court. Stop. The order passed by this bench. The contempt application stands disposed of. Next. Dismissed.
Lord, I have got the petition. Lord, I'm paying for direction to serve the copy of the contempt application.
You are there for the petitioner?
Yes, Lord.
All right, please serve.
6010.
6009 is dismissed. 6010. Serve.
Lord, serve and
11th of September, it is returnable.
my Lord.
611, I beg to appear for the petition. This is the first time the matter has come.
Please serve. Yes.
11th of September.
Yes.
612 of the alias contempt, the lordship is compliance report is there, lordship. Lordship, the contempt application itself, lordship is appeared page 23. I am the panchayat pradhan, my lord.
Let me see. Dekhi. Page?
Page 25 is the lordship. And notice has been issued by the panchayat pradhan. And page 27 is the my lord reason order along with the my lord reply. Page 26 is the reason order, lordship. They have filed
27?
26.
Very much
26,
serious copy of 26.
26 is the reason order passed by the as per the direction of your lordship.
Twenty-six is the possibly the communication. Where is the order?
27 is the my lord communication letter.
27 is reply for notice for contempt of court. Ramnagar Gram Panchayat.
Lordship. 26 is the reason order, lordship. They have served, my lord.
Just hand it up. Please wait. This page 28, see? It's your page is also 28. It is not 6. The way it has been mentioned. 29, 30. What is your decision?
Lord, decision is lordship is there. Lordship, the when the lord the
did you detect unauthorized construction or not?
Lord, part of the construction is unauthorized construction.
Then
Lord,
what steps have you taken?
Lord, this is the reason order, my lord.
Then this is not proper.
Not my lord.
Then what is to be done?
Lord, I take some instruction, lordship.
You want to take instruction?
Lordship.
Take instruction. Contempt application stands dismissed for default. Next. Did you file your wakalatnama?
Lordship, wakalatnama is in the meantime filed.
In the meantime, file means you have it with you?
Lordship, I have filed in the department, lordship.
Why are you holding it with you? You should have filed it.
Today, my lordship is handed over the lordship. That's why, lordship. I am filing.
You need to put a stamp over there and file it in the department. You are not required to do anything. Why are you holding it? In course of the day, it's already 4:35.
Lordship, tomorrow I'll lordship file it.
ওরে একটা লিভ দিয়ে দিন তো কালকে বকালে তোমার ফাইল করবে অলরাইট আর ডাকতে হবে না
very next, my lord.
All right, serve.
My lord, item number
My lord,
item
my
number,
lord, may I be permitted to mention, my lord?
613.
my lord, item number
My lord, may I be
314, my lord.
permitted to mention?
613 serve.
My lord, item number 314, my lord. In fact, my lord, this matter was taken up by my lords, my lord, in earlier occasion. My lord, on 31st July, my lord, this matter was taken up by my lords, my lord. And this was, my lord, upgraded. And my lord, pursuant to lordship's direction, my lord, I have served notice upon the DPPG. My lord, the matter is appearing, my lord, 314, my lord. My lord, this is a widow pension, my lord. Mr. Basu, Sandipon Basu appeared last occasion, my lord.
Who is appearing?
Mr. Basu is
Basu.
Banerjee, sorry.
Changing his surname.
31st July, this matter appeared, my lord. My lord was pleased to direct, my lord, once again to serve notice.
314.
314, my lord. Jayanti Banerjee.
Yes, Jayanti Banerjee. What
It was
happened?
upgraded.
Yes, yeah, pension not received.
No, my lord, pension received, my lord, but after recasting, my lord, this was my allegation, my lord.
Yes.
After recasting, they are giving the pension and the gratuity has been fixed, my lord.
Yes.
And, my lord, they have clarified my lord's order. So this is why, my lord, I filed this contempt application against the DPPG and main answering respondent.
Did you take
DPPG.
instruction?
Well, I am for the DMC because so far as DMC has done everything.
All right, then who is DPPG?
DPPG. I have served notice pursuant to lordship.
Who is appearing?
Well, I don't know, my lord. I have served notice last occasion, my lord. And this,
আচ্ছা এটাকে তুলে দিন তো একটু উপর দিকে 314টা পরে
My lord,
করে দিয়ে দেবেন
my lord, may I be permitted to mention, my lord, that my lord, your lordship had given order, my lord. It has not been uploaded yet, my lord.
Which
My lord,
order?
my lord, on 19th of August, my lord. My lord, an appeal has been filed, my lord, against
Yes.
that order, my lord. My lord, tomorrow the date is fixed, my lord.
Give the number.
My lord.
my lord, contempt application,
Yes.
item number 617,
হ্যাঁ
first time.
আচ্ছা 617 এর একটা অর্ডার দিয়ে দিন তো
My lord, item number 615.
আর ডাকুন 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 তাহলে গন্ডগোল হয়ে যাবে প্লিজ ওয়েট 614 is anybody there? It has to be dismissed. Next 615. All right, serve. Yes. 11th.
My lord, first time conduct.
Yes, serve.
615.
My lord, first time.
All right, serve. 11th of September. Dismiss. 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 Yes.
Permitted item number 359, your lordship. Lordship, I have affirmed one supplementary affidavit to add a party contempt on SDO, lordship. Lordship, what happened, my lordship, your pursuant to your order, Panchayat has given the order, but he has sent it to the SDO, and SDO is sitting tight. That is why, lordship, my humble prayer that the SDO should be party as a added contempt, my lordship. The SDO should and the
Is the panchayat matter unauthorized construction?
Yes, ma'am.
Difficulty is in a contempt, you cannot pass fresh direction. Do you get it?
On that,
If the SDO is not acting, then this gives rise to a fresh cause of action, and you have to take it up in a fresh writ petition. It cannot be done in a contempt. Are you getting it?
My
Which
lord,
item is this?
item number 359.
Who is your other side? Are you aware?
I have subbed, but I don't know.
You do not know. 359 ke পরের দিন একটু উপর দিকে দিয়ে দেবেন তো।
My lord, 444.
Hmm.
My lord, first time, my lord, contempt.
444. How did it go there? Are you sure it is for the first time? 444. এই একটু 444 কে একটুখানি দেখুন তো CPAN 1818 শৈলেশ CPAN 1818 প্লিজ চেক আপ 2024 ফার্স্ট টাইম কি করে ওখানে গেল অর্ডার হয়েছে কিছু See? You do not know.
ও ভাই ঠিক আছে ঠিক আছে